Said Lordship, I beg to mention item number 28. I, on behalf of U. Goswami, Lordship, due to some personal difficulty, he could not come today, Lordship. I've taken the consent of other side, Lordship. Matter may be adjourned for 2 weeks.
On the prayer of Mr. S.S. Roy
On behalf of U. Goswami.
and council appearing on behalf of Mr. U. Goswami, standing council,
CGC, Lordship.
and CGC. Come on, list this matter after 4 weeks.
Obliged.
I beg to mention item number 22, Lordship.
Hmm.
Matter may be adjourned and maybe listed after divulgation. We will file a rejoinder affidavit. We have recently received,
2012 matter.
yes,
No
we
adjournment.
have received some new
No
documents,
adjournment.
Lordship.
We'll see. No adjournment. We'll see.
Lordship, Mr. Ashish Dasgupta Senior
Huh?
will appear on next day.
Hmm?
Ashish Dasgupta, he is newly engaged. He will also appear in the next day, Lordship.
Whatever. We'll see.
We will file
2012.
a rejoinder affidavit.
2012 matter.
Yes.
No adjournment. You be there. Tell him call your senior. We'll see if any rejoinder is to be, it's required, we'll see.
Please, Your Lordship. Lordship like to mention item number 14 and 15, Lordship.
14 and 15.
Lordship, matter may kindly be passed on for the day, Lordship.
Why?
Lordship, as per last order, we need to take some instruction from our client, but he is out of station for some medical treatment.
Who?
Clients, Lordship. Petitioner is out of station for some medical treatment, so we are unable to communicate.
MS so learned counsel for the petitioner. Submits them. They were supposed to obtain some instruction from the client, from the petitioner. However, since the petitioner is out of station for medical treatment, no instruction could be obtained from him. Therefore, press for listing of the matter after
Vacation,
the 3 weeks. Praise the Lord. List after 3 weeks.
obliged, Lordship.
I think this matter, we fixed the matter for today only. Anyway.
Obliged.
Wait, please, my lord.
Yes.
We are employees of various polytechnic colleges across the state of Assam. Now, my lord, what had happened is that pursuant to the honorable court's order, my lord, one interim order was passed. My lord, we have been rendering our service since 2017, along with our contemporaries. The contemporaries herein being the petitioners, the opposite parties in the instant I. Now, my lord, while we were working last
You
year,
want to implement yourself
I want
as
to
a party
as
respondent or
respondent,
petitioner?
yeah, no, for the
Respondent.
respondents.
Yes.
I'm
yeah.
appearing on behalf of SC Biswas. He's coming, he's on legs, I think, in Songkor.
Hello. Till then, may I?
No, what the interim order is affecting you?
My interim order is affecting us because, my lord, there is one OM, my lord. Now that OM states that there are just 17 posts. So because of that interim order, we cannot be eligible because that interim order is protecting the interest of the opposite parties. So that is affecting us. And moreover, my lord, the opposite parties herein, they are all 40 plus, which is against the norms which is prescribed in the OM. So we being under 50, my lord,
Heard
50
Mr.
PR Sarma.
Learned counsel for the petitioner. And also heard MS.
Kelarian Khan.
So, learned counsel appearing applicant, huh? Sorry. Yes, Goro. Applicants, huh? So and so for appearing on behalf of SC Biswas. Learned counsel for the opposite party, writ petition. Next panel. This is an application seeking implement as party respondents in the connected writ petition with WPC 7001 of 2024. You are working as what?
My lord, we are working as in various posts, my lord, as sweepers and other grade 4 posts, my lord, like sweepers and other.
And petitioners are
The same, my lord.
Same.
Posts are same.
They are also working.
They are also working, we are also working. We are actually their colleagues only.
Hmm?
Colleagues, we are colleagues, my lord.
Hmm.
We are all grade 4 employees in the instant case. My lord, may I kindly say one thing, my lord? My lord, this honorable court, by the order dated 19/2/25 at page 120, has already allowed implement of a similar matter, my lord. Similar employees, similar case, my lord. This honorable court has allowed. Page 120, my lord will find the effective portion at 127. Last page of the IS. Already allowed, similar, everything is similar. That is of Nalbari Polytechnic.
Yes. You have any objection?
Lordship, my senior is on legs. So this
next
matter may be
Next.
passed over for a time being.
On, no, we're allowing it.
Okay.
No prejudicial post to you. Having considered the ground set forth in this application, I find that the applicants appears to be a necessary party in a connected merit proceedings, connected WPC in the so and so 700. Accordingly, Mr. Does the applicants are allowed to be implicated as party respondents in that writ petition and WPC so and so. Mr. Accordingly, the applicants will be allowed to be included as respondent number
17 to 82.
17 to 82 in the connected with WPC. So, next one. Writ petition instance. The IA states allowed in this purpose. Next paragraph. Writ petition in view of the order passed so and so. Who has to file? You have.
My lord, I have to file.
You have to.
I want to be.
The consent for the applicants to, and every person for the parties to file an amended course pattern. On receipt of the amended course pattern, registry to incorporate the names of the newly included respondent number 17 to 82. That was in the 82. No? This after 3 weeks.
Oh, my lord, 2 weeks.
Hmm?
Deeply obliged.
Need resolution. Lordship, this after a departmental inquiry, my lord, the petitioner was dismissed from service, my lord.
Lordship, in this case, I am praying for an adjournment, Lordship.
Why?
Some personal difficulty on the part of my senior. His leg is fractured, Lordship.
Who?
Mr. Ganguly, Lordship.
On many occasions, they are taking the same plea. Last time also.
Immediately after the view vacancy, he will be here,
One
Lordship.
is going to retire in after 2 years, my lord.
You have already dismissed.
Already dismissed,
The
but they are
service is
good
already
points, my lord.
dismissed.
There are good points, my lord, in this
Huh?
case. There are good grounds, my lord.
What are the grounds?
One of the ground is that past record has been taken into consideration, where in the letter of memo, there is nothing regarding past records. They have just said unauthorized absence. But when the penalty was imposed, they have taken into record past record. What past record? So that is one of the ground, ma'am.
But then your
And unauthorized absence also.
unauthorized absent already it's proved. Unauthorized absent
according
is
to
already proved.
It's proved, but whether it was due to circumstances beyond my control. So there was no willfulness on my part. I was not allowed to attend the office, ma'am. So those grounds are there in this case.
Madam, very difficult.
But I can
Where
try.
it's very, very limited.
I can
Scope
try.
is very, very limited.
But regarding the past record, there is an
Anyway, see,
judgment of the High Court only, my
he
lord.
is in some medical problem.
So a fixed date may be given, my lord.
Heard MS so and so.
JM form.
For the petitioner.
A Dhanukar.
Mr.
A Dhanukar.
A. Dhanuka, learned counseling. Submits that. Mr. A. Ganguly. Learned counsel for the respondent.
Lordship may give a fixed date, my lord.
A. Ganguly, learned counsel for the respondents. Is having some medical problem. Therefore, that matter may be listed. Matter may be adjourned for 3 weeks.
Lordship may kindly give a fixed date, otherwise it won't come again, my lord.
Prayer the Lord, next parent, in view of the. No, prayer the Lord, this will matter after 2 weeks. Give the date.
Give a
after
date.
3 weeks.
24. Okay. Deeply obliged.
Yes.
These petitions are regarding also provincialization of schools and the teachers, lordship.
Yes.
And they are looking.
Who is the respondent?
Respondents are also one prime minister, elementary education. lordship.
Yes, elementary education.
But till date, no affidavit has been filed by them.
It's okay, we'll dispose it of. What is your ground?
My ground is that, lordship. First, kindly will look at annexure 1, lordship. Annexure 1 document, lordship. They,
From same school or
no, different schools, lordship.
which district?
This all are Lakhimpur district, lordship.
Within the district of North Lakhimpur.
Or not Lakhimpur. lordship.
Lakhimpur, but then only difference is the different school.
Lordship.
Otherwise, claim and everything is same.
Everything is same, lordship.
Okay, so tell us any ground, what is your ground?
My ground is that, lordship, the diaspora, lordship, has been reflected for a certain period of time. For a
Yes.
particular school's, lordship, and thereafter for a particular period of time, it has been deleted from the database of the system, lordship. Thereafter, lordship, in the year 2012, my case has not been considered under the 2012 Act, lordship.
Because of
Because of some lordship, drawbacks in the documents and etc. lordship. And thereafter, the 2017 Act has come out, lordship.
where is the rejection?
Rejection, lordship. First, kindly we look at annexure 1. There is no such rejection, lordship, but my lord, annexure 1 document reflected that, lordship. Regarding Zayas code, may I read the, lordship?
Yes.
Type copy, lordship,
Hmm.
page 15. With reference to the above, I have the honor to inform you the following few. That sir, in 2006 to 7, for the first time, capturing of the date from the Venture School was started via DICE data collection format, DCF, MIS, SSA, Lakhimpur, has prepared a master list based on the various sources like records from the DU office, information from the concerned block official, receipt of information from other sources, etc. And initialize total 1, 2, 3, 3 numbers of new name of schools in the DICE software. Out of these 1, 2, 3, 3 numbers of schools, the data collection format from 1101 numbers school are received and captured by DISC software number DCF was received from the remaining 132 numbers of schools for 2006 and 7. The names of 8 numbers of schools against the school codes are found amongst the above named 132 number of schools whose data were found not captured in the so-and-so DICE. If any of school out of these 132 has submitted the DCI in 2007, it remained in the DIS database, but others were deleted from the database. When providing the list for 132 numbers of such schools is also provided as list of eligible answer school initialized in the years 1996 to 07 as pre-master DI number DCF received, list and closed. As such, the undersigned would like to request your honor that regarding any data of DICE for provincialization of venture school, if any list is being provided by the state mission office SSC Assam is considered, it will be the best source of data as during preparation of such list for provincialization of venture schools, it may be viewed from all the angles based on the act of provincialization. Here, Lordship, there is a list, Lordship, and in the list, the petitioner school is the page 23, Lordship. Mukul Sapuri LP School, one. Ten number, Mukul Sapuri, Lordship, against the school code.
Huh?
At page 23, Lordship,
Huh?
serial number, this is 10.
There is no serial number.
10, Lordship.
Oh, serial number.
Serially, Lordship, there is no serial number, actually, serially 10, Lordship, Mukul Sapuri LP School. And there is,
Sapuri. Murkong Sapuri.
here it is actually Mukung, actually, it should be Murkong. Murkong Sapuri. And school code is also reflected in the right hand column, Lordship.
Huh? What do you want to say?
Okay, my submission is that during that period, Lordship, in the 2006, 2007, Lordship, my school name was in the database. That my school was existence at least during that period of time, Lordship. But it was deleted due to some technical reasons, and it was also admitted by this letter, Lordship. And this letter is addressed by the DEO Lakhimpur to the DEO Lakhimpur and District Elementary Education Officer Lakhimpur, Lordship. Thereafter also so many communications were going on, Lordship. And finally, your Lordship has kindly looked at Annexure 3 document. It is also a type copy document. Here, Lordship, it is also submitted the database of these schools, left out schools, Lordship.
So your school also.
My school also there, but my lord, the director of elementary education has yet to take any decision regarding this these documents, Lordship.
Huh?
Annexure 3, Lordship,
Yes.
physical verification report regarding all these left out schools have been submitted by the DEO Lakhimpur, District Elementary Education Officer Lakhimpur, to the Director of Elementary Education Assam. Write the letter dated 27/8/2022, Lordship. But in respect of this letter, the Director of Elementary Education has yet to take any decision, Lordship. They have not taken any decision. Because it was the admitted fact that these schools were left out from the purview of the provincialization of schools under the 2017 Act, Lordship. But it was submitted by the Director of Elementary Education Officer by the letter dated 27/8/2020, Annexure 3 document to the Director of Elementary Education Assam, but they have not taken any action against this, Lordship. It is still pending also.
Yes.
Well, limited if there is the Lordship, if possible.
Consider and decide.
Lordship,
Take a decision.
Lordship can dispose it of by directing the director to basically, my lord,
Consider and dispose of.
my lord, pass the reason order upon due verification, my lord, upon due verification.
There are different schools.
different school, Lordship.
How many schools?
Here, Lordship, 10 and 11 schools, Lordship.
Lordship
We'll
will,
just give the list of, it will disposing of it to
Lordship,
one
Lordship.
order.
Lordship will also highlight there that the director can individually see all schools because all facts and circumstances will be different in different schools, my lord.
Heard, Mr.
R coupon, Lordship.
Learned counsel for the petitioner. So dispose of. And also,
My lord, A. Fukan, my lord. A. Fukan for the elementary education department.
the standing counsel for
So,
elementary
Deputy
education
Commissioner.
department. For respondent number,
my lord, 1, 2, 5, and my lord, 7.
1, 2, 5, and 7.
And my lord, my friend is appearing for 4, my lord. Respondent number 4.
Be there. State council. Learn is the state council for respondent number. Next step.
Uh,
Having considered the nature of the grievance raised in this writ petition, and also considering that the similarity of the issue on facts and law, these writ petitions, these bunch of writ petitions are disposed of with the admission institution by this common order. You are teachers.
Lordship.
Teachers, you are for provincialization of school or your service?
My service and also school also.
Your school has also not been
Lordship.
provincialized.
No.
Even in 2012,
Yeah.
11 Act or 11. It
Yes,
is
with the ultravirus, the act which was ultravirus.
and even even after.
17 or
So that aspect also has to be seen.
Your schools have been established since when? From
from my
1978.
1978.
You just give the those.
Lots
For
while
every
provided.
school, different school.
Lots while provided.
Next paragraph. The short issue. No, the case of the petitioner. In brief. No, next paragraph. No, not that. By filing these writ petitions, the petitioners who claims to be working, still working,
Lordship.
claims to be serving as
Assistant teachers.
assistant teacher, all in the different schools of Lakhimpur district
Lordship.
from Assam. Challenges the non-provincialization of the service, non-provincialization of the school, of their school as well as their services. On the ground that they are, the schools as well as the teachers are having their are having the required criteria as per the Assam so and so Act 2011. Just give the name of that act as well as the subsequent enactment by Assam Education Provincialization of Services of Teachers and reorganization 2017. Next paragraph. The petitioners claims that they are serving as assistant teachers in the different schools, namely, you just give the name of the schools
Lordship.
in the district of Lakhimpur. Their schools were established ranging from the year 1978.
1978.
Last give the last year of establishment of both those.
21 to 1970.
Huh?
21st of February 1978.
No.
Only year, Lordship.
First, initial, all these schools, how, I mean, when they were, these schools were established,
Lordship.
not in same year, it is same year.
No, in a different year.
That's what I'm saying.
Lordship.
You just give the first
I
year,
will prepare a chart and give all the details, Lordship.
not chart, you just give now. Since I'm saying first schools, the year of the first year of the year of establishment of the first school, then the last, first to last. All right. Ranging from 1978 to sorry. Next paragraph. The Mr. So-and-so learned counsel for the petitioner submits the since the petitioners schools no, since the petitioners since the schools of the petitioners and their services are required to be provincialized in terms of the so-and-so Act of 2011. Thereafter, the new enactment of so-and-so 2017,
Lordship.
and the responsible authorities having failed to consider the case of the petitioner are deserved to be considered in accordance with the above enactments. Mr. So-and-so, while referring to the various documents, last being the letter dated 27/08/2020, submits that a concerned authority has submitted the Annex 3.
Answer 3, Lordship, page 35 is the original copy and others is hard copy.
You have not, they are wrongly, you have tapped wrongly, which is addressed to the
Oh, it is wrong,
director.
Lordship.
You have said the district
I'm sorry for seeing this type wrong.
concerned authority in the I district elementary education officer, Lockenpur, has submitted the physical verification before the Benson LP public UP schools to the director of elementary education, son. However, agent that no consideration has been made by the director of elementary education, son. Therefore, he submits that the director, the responsible authorities may be directed to consider the case in the petition and to provincialize their school as well as their services.
To verify and,
No.
Go ahead.
It's his submission
okay, ma'am.
and provincial the school and as well as the services of the petitioners in accordance with the relevant provisions of the Act of 2007. Next paragraph, Mr. F. Foucault, Standing Council Elementary Education. Here is that. This is the case of the petitioner. Appears to have not been considered. The responsible authorities may be directed to consider the case of the petitioner strictly in accordance with the provisions of the Act of 2024. on consideration of the submissions and the documents annexed to the petition. The submissions of the council for the. So, considering the documents annexed to the petition. Petition. It appears that the case of the petition has not been considered. Even the repeal act of 2011 as well as so and so 2017. Yes. Of course, the consideration under the so and so act of 2011 has been repealed. There is no question of consideration under the order. That is his case. However, the provisions of subsequent enactment, i.e. so and so 2017, provides a procedure and criteria for provincialization of venture schools and the services of the teachers, mainly employees of the said of the respective venture of the venture schools in the state of Assam. Admittedly, the case of the petitioners appears to have been not considered by the responding authorities. Having considered above, considered view that the responding authorities are obligated to consider the responding authorities are mandated under the law to consider the case of the petitioners and take a decision as to whether the schools, whether the venture schools and the services of the employees of the school, including the teachers, are to be provincialized or not. What is that? Having considered that. Whether the venture schools under the relevant law, under the relevant act, Mr. Thus, I deem it appropriate to direct the responding authorities to consider the case of the petition. Accordingly, the responding authorities, particularly
None of the director.
respondent number,
My lord,
Number 2, Lord.
respondent number 2, i.e. Director of Elementary Education, Government of Assam, to consider to verify the claim of the petitioners of the each school and the teacher.
Individually.
Each schools and teachers, each school and teachers of the different schools in the district of Lakhimpur. The no, no. We verify and consider and verify and consider. And pass approve with all this. The entire exercise is directed in the hearing level. And the entire exercise to be taken as directed hearing level shall be made within a period of 4 months,
My lord, can it be 6 months because it's too many schools, my lord?
6 months.
6 months from the date of
Date
receipt.
Receipt of the copy of this. Yeah. It is provided that any decision that may be arrived with by the authorities, the respondent authorities shall be communicated to the petitions. The petition is still displayed.
Yeah.
With petitions.
Deeply obliged.
May I
May
please-
please, your lordship.
Lordship. May I please, your lordship? Lordship on the,
Where the lawyer, where this counsel? Earlier counsel. Yes. Mr. Fukon, you just give that date of year and the name of the schools. Serially. Yes,
May please, your lordship.
yes.
On the earlier occasion, lordship, finance department were directed to take an instruction, lordship, whether the proposal has been received or not, lordship. Lordship, there are several orders, lordship. Lordship, the fact is for non-payment of salaries, lordship, to the husband of the petitioner, lordship.
Yes,
lordship, I'm for respond number, for the Hills
Pujari.
Area Department, lordship.
any instruction?
Yes, my lord, that proposal was wrongly sent to the finance department.
Okay,
So the concerned administrative department, the employing department is the Hill Areas Department. So we have sent that proposal, reverted back that proposal to Hill Areas Department. And we have asked them to speed up the matter. We have sent a reminder also, but nothing, my lord, is forthcoming from Hill Areas Department. Hill Areas Department.
Hill area.
Yes, now the factual matrix in a nutshell is that there were altogether 10 numbers of persons. My lord, in that, my lord, Dima Hasao, North Kasar Hills district, who were, my lord, casual employees, grade 4 master role workers, and they were sought to be regularized. And therefore, my lord, the proposal was sent, my lord, leaving the husband of the petitioner. His name was not sent. His name was, somehow it was dropped, it was left out. It was the mistake committed by the authorities of the Dima Hasao. Then, my lord, nonetheless, those in respect of those 9 persons, everything has been done. They have been brought under regular cadre. They are receiving the benefits. In the meantime, that person, he expired. Now his wife is before this honorable court. Now, the fact that, my lord, inadvertently or deliberately, whatever may be, my lord, his name was left out. We have now requested the authorities to take a re-exercise and do the needful. Accordingly, again, my lord, they have committed the mistake. This my lord, Dima Hasao, my lord, council, and they have, my lord, sent that proposal directly to the finance department. We said that we cannot do it. It is to be intra-government department. So therefore, we have, my lord, returned that proposal to Hill Areas. Now it is pending before the Hill Areas department.
Yes.
She is to give the clarification.
Lordship, as per the last dated order, lordship, we have received an instruction regarding the later dated 10/12/2024, lordship.
What is the instruction? Tell us.
Lordship, may I read, lordship? in
Tell
inviting
us what are reading also.
Lordship, in this regard, Lordship, the Principal
you are not
Secretary North Kasar,
uncomfortable.
Hills Autonomous Council has been requested to look into the matter diligently. Lordship may Lordship, we have forwarded the matter to the parent department, Lordship, because as we have it is stated in the instruction, Lordship, it's a very old matter. For a speedy recovery, Lordship.
Has moved for proposal of arrears salary in favor of labor also after a long duration of 18 years. Who is not alive now in not approved in due course of time. In this regard, principals also has been requested to look into the matter. Who has to look into? You.
No, Lordship, the department, Lordship.
Then why you are passing the buck one after another? Yes. Now the ball is in your court.
Because again, my lord,
18 years.
yes, it had reverted again back to my lord, the Dimahasa. Because initially my lord, fault was committed by the Dimahasa District Council. Had the name of the husband of the petitioner been
Only
said at that point of time,
papers are okay.
my lord?
Papers are okay.
No,
Only it was placed in a
No,
wrong
we do not know.
department.
We do not know.
I
Therefore,
clarify.
my lord, a fresh
I
proposal
will
is to come.
clarify, Lordship.
Yes.
Lordship, to some extent, my learned opinion is also wrong, Lordship. Actually, the fact is that percentage selection procedure, Lordship, 10% were appointment, Lordship, appointed,
we're
Lordship,
not going
in
to
sanction
all
back and forth.
It's not a question that we are not going to. How they have not completed? Because it's
That's
a, they have admitted that you are entitled. Entitlement is not the issue. Issue is when they are going to
Lordship, yes,
complete it. That's it.
Actually, Lordship, Dimahasa Autonomous Council, Lordship, send the
No,
proposal of
issue of
10%,
issue of
Lordship.
no use blaming.
Initially, Lordship.
I mean, indulging in a blame game.
Yes.
Forget about it.
Yes.
Of course, you have filed a petition. That's why we're concerned. So now it's back to you. How could you be so irresponsible? 18 years. You completed by within 1 month.
We'll send it to the department.
Huh?
We will send it to the health department,
Hill area.
hill areas department,
Then
then they will follow this.
to the finance. Completed within 2 months, including the finance.
The finance, my lord, we will take a call, my lord, once the papers are there, my lord. They will have to give the,
What you have to do? What he has to do now?
he has to now make the calculation and arrange all the papers, my lord, regarding.
To the hills and then send
Yes,
to the
everything
hills.
has to be transmitted to the parent department. Now,
Hills department.
yes, after it is transmitted to the parent department, they will examine and verify the entire matter, taking into account the established legal principles, and then, my lord, they will send it to the finance department for concurrence.
2 months,
Lordship,
3 months,
3 months.
3 months. Within
Lordship
3
will
months.
keep this
Entire from here to her, from him to her, and then you to you. Then again, we'll go back there.
Now, my
Once you
lord,
clear, it will go back to the hills.
now
Hills.
that,
And then Dimahaso.
yes, so
We'll
that-
release that, Dimahaso.
yes, now the difficulty here is that, my lord, they will have to admit it, my lord. The hill areas department will have to admit that he is entitled to the relief as sought for.
No, this is what he's saying.
admitted.
There's no
Admitted,
dispute regarding the entitlement.
Admit, I said there.
Request to look into the matter diligently and take necessary action, resolve the matter at the level by this
No,
department.
they have not admitted per se, my lord. Kindly see, my lord. Again, my lord, this will give to multiplicity of proceedings. Give rise to multiplicity of proceedings. Therefore, my lord, lordship may be pleased to keep this petition pending, my lord. This honorable court will monitor. Have they filed affidavit? Thank you. কোথায়? Affidavit কোথায়? কোথায় affidavit? Oh, so you made a wrong purpose. Where is the hill area department affidavit? Then? Please don't mislead. So we are trying to help him out, my lord. In the writ petition, he makes a
have you filed-
categorical environment.
Have you filed the affidavit?
No,
Nobody files an affidavit.
no, because we are the last department in the line, my lord.
Yes. Have you filed the affidavit?
Yes,
Yes,
sir.
mister. What is your stand?
They have stated, my lord, that the proposal was not uploaded due to unavailability of relevant documents. It is neither, it is not admission per se, my lord. That affidavit
your
is also neither here nor there.
You are not saying that he is not entitled.
That is silent, so
Proposal
therefore,
could not be said. What does it mean? Because of certain technical issue.
so
They are
therefore,
not saying that she is not entitled or that.
tomorrow they may say, my
husband
lord.
was-
No, tomorrow.
Until that time, they have not said where. We cannot.
No, my lord, they have not
We
said.
cannot wait for them to say.
No, therefore, lordship,
That's why I'm asking what is the affidavit? The affidavit, because of technical, whatever may reason, they could not send the proposal. That's all.
no, under
We
that,
tell them to send the proposal immediately.
no, under that circumstances, my lord, if my lord issues a mandamus, if tomorrow, my lord, we on examination at the end of the line, the finance department finds my lord that he is not entitled to, then my lord, again, my lord,
You cannot just see, this is on record, it said,
No,
since after 18 years, they have started.
therefore, my lord, lordship will keep
See
this
the
writ
plight
petition.
of the petition.
No, lordship will issue a stricture, my lord, keeping this writ petition pending, stricture, my lord, the departments, these two departments.
Including you.
No, my lord, we are at the end of the line, my lord, we definitely take a call, my lord. We are not escaping the issue, my lord. We'll definitely take a call.
We'll just say that we'll expect that the authorities shall would complete the process within 2 months. We'll just say, we'll not issue a direction. We'll keep it pending.
Yes,
Lordship,
yes, that's what.
We'll just
Lordship will
say-
examine, my lord, because,
Lordship.
because
We'll
at
keep
the,
it pending.
Lordship pending.
Heard Mr. So and so,
Yeah.
learn counsel for the petitioner. Give them. One chronologically. And also heard, uh, next para. You record all their name, huh? By placing the communication that is 24/03/2025 from the secretary to the government of Assam, Hills Area Department, this school, Hills Area Department, MS A. Talukdar, learned, standing council, learned, huh? State council submits that after having after taking note of the undue delay of 18 years for moving the proposal of area and salary in favor of in favor of the late husband of in respect of the late husband of the petitioner, the principal secretary, North Kachar Hills Autonomous Council has been requested to look into the matter diligently and take necessary steps, action to resolve the matter. Mr. Mr. C. Sharma, learned standing council, North NC Hills, submits that the appropriate action would be taken shortly. Thereafter, the proposal shall be submitted to the concerned departments through the parent department, that is
My lord, the hill areas
Hill
department.
Area Department, Hill Area Department.
My lord.
Thereafter to the Finance Department.
My lord.
Mr. Arbor Pujari, Land Standing and Finance Department. Submits that. As in when the proposals are as and when the proposal is received, definitely, certainly the Finance Department would decide, they would take the steps as required, which would be required.
We will consider. My lord, we will consider and take
As
appropriate
as
decision.
would be required.
Yes, my lord, we'll take
As
appropriate.
would be
My
required.
lord, my lord, my lord.
Having considered the submissions and considering that the concerned authority has moved the proposal of the entitlements of the late husband of the petitioner after hopeless delay of 18 years, while keeping the writ petition pending, it is expected that the respondent authorities would complete the entire process for payment of arrears salary in respect of the late husband of the petitioner within a period of 2 months from today.
That's it.
We'll list after 2 months.
Lord,
All right,
that's it.
let this method be listed after two months.
The date will be fixed, Lordship.
2 months, we'll see, 2 months.
Admittedly,
On the next date, it is expected the respondent will place the completion of the entire process and possibly the release of the areas essentially to the petitioner. And I'm saying expected,
no, absolutely, my lord, absolutely, everything, my lord.
Obliged, Lordship.
have some value to the order of the court.
Absolutely, but there is no fault on his part. That is the, my lord, pathetic
See,
condition.
we understand
Yes,
the
my lord.
process, it
Yes.
takes time by the
It
government.
is only because of the default committed by the, my lord, initial appointing
You are
authority.
the spokesperson of your client. I mean, mouthpiece of your client. So it
I'm
is up to
obliged.
you how you advise them
Yes,
to
absolutely.
move on.
I'm so obliged.
May I please?
Yes.
This is committed pertains to non-payment of the.
Lordship, can this matter be taken after some time?
Why?
Lordship, the council for the health department is on legs.
This is also payment of pension. Subject to positive instruction.
After some time.
Lordship, can this matter be also taken up after some time?
What is this?
Pension matter, my lord, I am 75 years old, my lord.
Hmm.
I've not received any pension. in my
After some time.
Okay.
What is the matter?
My lord, item number 18, my lord, subsequently, maybe the
Huh?
item number, my lord,
Item 18.
18,
What is this?
18 is first.
2785, my lord.
No, what is the matter?
My lord, matter related to my lord, the petitioner before lordship, my lord, they are duly selected by the PTA authority, my lord, for a record or certificate class 4 training, my lord.
Yes, yes. Ah,
My lord.
your selection was
Too heavy, no? So,
My lord,
without due publication of notice and advertisement.
my lord, rule does not permit, my lord. Not permit means, my lord, there is no provision in the rule, my lord. It is to be published, my lord.
See, there are so many recruitment rules.
My lord.
Where does it say
This- That is the crux of the matter, my
No,
lord.
no, where does it say? Every rule doesn't contains that for appointment or filling up or whatever is to be by way of advertisement or it has to be notified. It doesn't provide.
My lord,
Have you come across?
my lord, my lord,
I have never.
my lord, that is correct, my lord,
Maybe exceptional may be there.
my lord,
I maybe slipped on it,
my lord,
but as far as we come across,
my lord.
every rule made under by the legislature or under 309, proviso to 309, no rule would contain the post has to be filled up by way of advertisement or notification. All right.
That is correct, my
It
lord.
contains the requirement and what is to be done, what is not to be done, procedure and requirement and the qualification, of course. So this is in consonance with the constitutional scheme of public employment. I mean, it's a letter. I mean, it's a letter for employment. This training is letter for an employment, right? Is not it?
My lord, my lord.
The moment you get the training, it's not that automatically you will be appointed. It's not it. Is it
No, no.
so?
My lord, this training, my lord, just to qualify to apply for the, my lord, each blood model post is, my lord, advertised. This is not for recruitment, my lord.
Yes.
The, my lord,
I
whatever list
understand.
prepared by the, my lord,
I'm just drawing an analogy to the recruitment rule.
my lord.
You said rule doesn't provide for notification. I said even in for appointment of a particular post, rule doesn't provide for advertisement. But law says it has to be preceded by advertisement.
That exception is
So
there.
how
my lord.
we have been picked up?
This exception is there, my
How you have been picked up?
lord. That is my
You
lord.
are
I'm-
giving an opportunity to other persons.
My lord, I'm providing one rule, my lord, that is, which is now, my
Is it
lord,
annexed?
involved.
Has it been annexed?
My lord, no, my lord,
It's not been annexed.
not the next, my lord.
Yes, let us see the rule.
My lord, this is the rule, this is a type copy, but it's not legible, my lord, this is a type copy, this is a, my lord,
Give the legible one.
my lord, this is a type copy, my lord.
Anyway, who is working on, who is undergoing training? Nobody.
Now,
Nobody, my lord, it is kept on hold, my lord.
Huh?
Because of the status quo order, my lord, is kept on hold, my lord.
Let us say, what is the rule?
My lord, this
What
is the
rule
rule.
is this?
First of my lord, the BTC is a 6 area, my lord. So 40 subject has been transferred to the BTC, my lord. In case the 40 subject, my lord, BTC have the power to legislate, my lord, make rules whatsoever, my lord, what is that they are requirement, my lord. So till they met, what is not applicable in my lord, state of Assam, before creation of the BTC, that will be applicable subject to their modified application on the basis of the governor notification or decision of the council. That is a law, my lord.
Is there any dispute?
No
So far-
dispute, my
So
lord.
far as the case is concerned,
There is a dispute, my lord.
there is.
Because under which law they have been selected, my lord, this is not applicable to BTC.
That's why I'm asking. I
My
don't
lord.
know. I'm
My
not
lord.
gone into deeper.
My lord. Lord,
That's why I'm asking, is there any dispute to
my lord,
with regard to?
my lord, that has been challenged before the division bench, my lord, that day I have mentioned before lordship. That matter is pending challenging that rule, that is in their selection, challenging their advertisement and their selection, that they have no authority to, without adopting the rules of the government of Assam without government notification, without a decision of the council, by a government notification, they cannot apply, my lord, in total. My lord.
By you. Who
By
is challenging?
BTC, by BTC, my lord. By BTC, my lord. No, it is challenged by the my lord who are earlier, my lord, they have completed RCC training, they have filed the petition. I am the council, my lord, in this case also. My lord.
So you are challenging the
My lord.
application of
My
code
lord, my lord,
that without there being any formal adoption.
my lord.
It's been
My
a
lord, lordship may come to
six
the
schedule,
paragraph 12 of the my lord, 6 of the
six schedule area
my lord,
could not have been.
my lord. And
So the selection is based on this rule.
my lord, not this one, the 2022 rule, my lord, which has been not
Just
been
understood.
adopted.
What about this rule? Why you are referring this rule?
This, because my lord, we have been selected on the basis of this rule,
Okay, let
which
me-
is my lord
let us
now
take-
in force.
This has been adopted.
My lord, this is adopted by virtue because BTC 1992 rule prior to creation of BTC, by virtue it is all adopted, my lord. And there is a notification,
Interpretation of the clauses of the
my lord,
six schedule area.
my lord.
Okay. Yes, which rule?
My lord, lordship may come to the rule, my lord, the 92 rule, my lord. And second thing, my lord, the rule is only for my lord, officers else who are want to join is a mandal, my lord. That is a my lord, anybody can go for training, but that rule is only my lord, recruitment and service rule, my lord. That rule is not recruitment service, not my lord, training rules, my lord. 2023 rule, man, under which they are selected.
Sir, first let us know.
My lord, my lord. Sorry, my lord.
I'm ignorant about this rule.
My lord, my lord. Lordship may come to this, my lord, rule, my lord.
Please,
My lord,
enlighten.
the type copy one, my lord.
Please enlighten. Yes,
My lord, this
1991
Assam
rule.
survey and settlement training rules,
yes.
my lord. So under this, my lord, Lordship may come to my lord for the recorder certificate course, my lord. So thereafter, Lordship may come to
Chapter 3.
11 also, my lord. Paragraph, rule 11, page 6.
First, which rule?
My lord, 92 rules, my lord.
91.
92, my lord.
91.
They have
Assam
notified as
survey-
92, but it is adopted in 91, my lord. That Lordship is correct, my lord.
Assam Survey and Settlement Training Center rules.
My lord.
1990. Yes.
My lord, my lord.
So,
Lordship may come to rule 11, my lord.
yes.
This is what there will be ordinarily be following 6 courses in the center. This is the Assam, my lord, this training institute is my lord, survey and training center is only for the to give this training, this kind of training, my lord. For the officers who are already employed, my lord. Record certificate course who are not, my lord, neither they
You are
are.
concerned about B.
I am concerned with B, my lord.
Yes, then.
So these are the officers my lord, who are in the government job. B, my lord, anybody can go. Lordship may come to then, my lord, page 7, rule 15, my lord, regarding B, my lord. Recorder certificate class code training. I have to read all the paragraph up to 23, my lord. Rules, my lord. May I read, my lord?
Yes.
My lord,
Rule
My lord.
20.
my lord.
For admission in
Everyone, each course,
the
director will
director will
invite
invite
application from the, my lord,
intending candidates
my lord,
by the middle of June each year.
my lord.
Yes.
Then, my lord, should come to rule 23, my lord, next, my lord.
Candidates for admission be selected on the either of the following managers. Yes.
My lord, these are our general procedure what lordship, my lord, earlier just mentioned, my lord. Then lordship may come to the, my lord, page 11, my lord. Note 1, my lord.
What about the rule 20? Inviting applications.
Rule 20, my lord, this is there, my lord. So
Yeah.
this is for, my lord, in general area, my lord. For the exception in council area, my lord, that is in note 1, my lord. Page 11, my lord.
Hmm.
Bottom of the page 11, my lord, note 1.
Candidates imputed by other states, district councils, public and private entities, bodies and private and city and this and those to principal. Yes. So what do you want to say?
My lord, may I read, my lord, to my understanding, my lord. Candidate deputed by the states. District council, my lord. District council is here, my lord. Public and private undertaking, enterprises, bodies and private individual seeking admission as private student. This two is not applicable, my lord. Answer with recorders work against permanent packages and recommended by the deputy commissioner for training.
See, individuals seeking as private students.
No, my lord. Here district council is separate, my lord.
No, candidate deputed by other so-and-so bodies and then as private student, it has to be private students.
Private also, my lord. The
Huh?
district council also, my lord. District council is separate, my lord.
Yes, if the district council send them as a private student,
My lord.
not as a general student,
My lord.
after the invitation of applications.
No, my lord. Here district council, comma, my lord. Then public and private undertaking.
Obviously, if the district council, let us see, for this case.
District, my lord.
District council
So, my lord,
sends-
if district council,
sends
my lord.
private students, then only. This will
No,
apply.
my lord. To my understanding, my lord, district council is separate identity, my lord. Cannot be. It
See,
is
you
public
can't-
and private undertaking,
See, you
enterprises,
cannot-
it is
you
there, my lord.
cannot have a contradictory provision. Look at rule 20.
Well, anyway, my lord, then last line of the paragraph, my lord. Need not be subject to entrance examination, my lord.
Yes. When it is sent as a private students, otherwise, you have to invite application,
My lord.
director. How the application is invited? He cannot just go on his
The
own. He
application
just
invite-
cannot go
that-
and
that
ask
part is
that
there,
you give me the application. It has the invitation or application means it has to be notified by advertisement, right? Okay,
My lord.
it's called split. Next.
Next, my lord. This is, to my understanding, my lord, district council, if they wish to send, my lord,
Private students.
no, my lord.
Private students.
My lord, this, I
As
think,
a
my lord, I have to go
private
the
student,
original,
you have to read.
original copy. My lord, to my understanding, my lord, maybe, my lord, because my lord, district council is separate, my lord.
Candidates deputed by other students, district student, public and private.
Private undertaking and enterprises bodies, that is it. Public
And
is involved
private
there.
individuals seeking admission as private students, it has to be read, it's a one-line sentence.
My lord, the comma is here, my lord,
Comma is
disjunctive,
deputed
my
by
lord, here.
other states,
This is not adding, my lord.
district councils, right?
My lord, when candidate deputed by state, that is different, my lord. By district council, different, my lord. Public and private undertaking / enterprises bodies and private, even private also can go, my lord, individually, he can apply. Because there is a process for paying fee if somebody he himself want to go, my lord. That is gone, my lord, earlier also on my private endeavor, my lord.
Yes, next.
My lord, this is, my lord, that's why, my lord, there is a, my lord, not advertisement, the notification is there,
So,
inviting
therefore,
application.
according to you, since this note 1 clarifies that this rule will not apply to the district council
My lord, other one, my lord,
or the sixth schedule area.
my lord,
That is what you are saying.
my lord.
That cannot be read into.
My lordship may come to that, my lord.
Absolutely, I think absolutely,
My lordship may come to paragraph 12 of the 6th schedule, my lord.
yes,
Paragraph 12, my lord, constitution.
I have seen that. It's okay, you read it.
my lord, it is specific in paragraph 1, my lord.
Yes.
They have to adopt, my lord. The BTC have, if,
No, that is one aspect. Other aspect
my
is
lord,
disputing that. You are trying to interpret this rule. Since the note 1 says that if the district council wants to send a private, want to send the candidate,
Mm,
no entrance examination is required. Since the district council has sent
my
them,
lord,
no entrance examination, no advertisement. This is what you are trying to say.
my lord, advertisement actually,
Or are you
there's a
saying,
notification, my
that
lord,
because of this note 1,
my lord,
it excludes the applicability of this rule
my lord.
to the 6th schedule area?
Right.
No, I'm asking.
My lord.
I'm
No,
not clear.
no, but this rule inclusive, my lord, because it is 1992. BTC was created by 2023, my lord. 2003, my lord.
Hmm.
So whatever law, my lord, prior to creation of BTC, by virtue of automatically applicable, my lord. If they want to, my lord, my lord,
Mr. Saren, matter is very simple. What you are saying is that the rules of the state, and the law and the rules of the state.
my lord.
And I had a privilege to deal with this thing regarding that thing.
But if, my lord, the council,
in the act, the same law regarding the Statehood Act
my lord,
of the state of Arunachal Pradesh.
my lord,
Not sitting here, not as
My
a
lord, my
state,
lord.
but as a lawyer.
my lord, as I think as you, my
So
lord.
as per that paragraph 6
My lord,
or 12
12, my lord.
of 6th schedule, what you are trying to say is note 1 excludes
My
the
lord.
applicability, or are you saying that because of the note 1, the other rules will not apply?
My lord,
Or are you saying that this rule will, unless it is adopted,
my lord.
will not apply?
So this will apply, my lord.
Okay,
92, the 2003 will not applicable, my lord. That is not adopted, my lord. My lord, the 1992 rule is prior to creation of BTC.
no, what you are saying in that case, if I correctly understood, this rule will automatically apply.
Apply, my lord.
Therefore, by application of this rule,
My lord,
by reading the note 1,
my lord.
this is the, in your case, district council has sent the candidates,
My lord. My lord.
right? Therefore, no entrance is required. That is what you are saying.
My lord.
So the applicability is not the issue.
My lord,
According
not an
to-
issue.
You are saying that this applies
Applied
because of the
accordingly, I
note
have
1.
forward, our names were forwarded for training.
Or note 1,
My lord.
since no requirement, since the state has already sent
My lord.
the candidates,
Exactly my submission. That is my.
so no requirement of
My lord.
advertisement, no requirement of entrance exam.
My
That is what you are saying.
My lord.
So-
And my lord, the learned, my lord, the other private respondent, my lord, they have been, my lord, there is advertisement, my lord. They have been selected. That advertisement has been issued under the my rule, that 2023, my lord. 2023.
By whom?
By the BTC, my lord.
BTC.
My lord. By
Same 6 schedule, same authority.
my lord.
Same
Authority, same, my lord.
Yes.
Only that, my lord, my
So
lord,
according to you, this 2023 rules,
my lord, is a recruitment rule, my lord, and
Rule.
service rule.
service rule framed by the state,
State, my lord.
unless after the establishment of
BTC, my lord.
BTC
My
or
lord.
the 6th schedule area,
My lord.
this will not apply
Applicable, my lord.
until that time it is adopted.
Adopted or by
In
any
view of the
modification, my lord.
Paragraph 12 of the
My lord, my lord. That-
6th schedule. Yes. Yes.
And the last line of the paragraph 12, my lord, is my lord, more because there may be confusion. That's why there is a, my lord, 2, my lord. It paragraph 12, 2, my lord. Any direction given
Land Record Service Rule 2023. What is the relevant provision?
or all even, my lord, still may come to the first, my lord, paragraph 3, my lord.
Paragraph
Rule 3, my lord. Class and cadre.
includes the land records officer.
So here is, my lord,
Land-
is a recruitment. Not sending for training.
How they can apply? Suppose even if rules applies,
My lord.
how can these people be sent for?
Even if it is
Can they-
applicable,
can they-
assumed to be, my lord,
Yes.
they cannot send for, my lord, training. They have to send for against the post. That is the selection, my lord, rule, my lord. This service
No,
rule, my lord, recruitment rule,
Even if it applies,
my lord,
the candidates cannot be sent under this rule
my lord,
because it's for recruitment.
my lord,
That
recruitment
is what you are saying.
against the post, my lord. 150 posts not available, my lord. Because, my lord, that is under challenge, my lord,
That is your second leg of service.
my lord,
Yes. Therefore, your selection
my lord,
for training
my lord,
is in consonance with the law.
law, my lord, and
And
according,
their selection is against the law.
my lord,
Huh?
my lord.
Okay. Yes.
Lordship. Mainly case is very simple, Lordship.
Yeah.
219 candidates who were selected by the secretary. That is without consultation with the other lordship. We have stated clearly in our affidavit, Lordship. That is the problem, Lordship. We have no
Consultation with-
record
Consultation with whom?
other authorities of BTC Lordship. Secretary had himself selected them.
It is something more of a factual thing which you are alleging. Come to the law point.
Against your officer.
Have you
But-
heard what he has said?
Yes, Lordship, but
They
Lordship,
said in terms of the para 12 of the sixth schedule
yes, Lordship,
clearly provides that the law
law which we have to adopt.
which has
Lordship.
been in existence before the creation of the council will apply. Therefore, this 1998 rules, which provides for training and all this thing, for sending of the candidates for training, although requires the invitation of applications, but as per the rule 10, note 1, provides that if the council sends, all right, no entrance, nothing is required.
That is
Subject to, the interpretation. That is what he has said.
Lordship.
Number 2, since you have said that the candidates who have been sent subsequently selected by the authority is in terms of the rule 23, the recruitment rule of the Assam Land Records and Subordinate Revenue Rules of 2023, which has been framed after the establishment or the constitution of this sixth schedule area, BTC. It would not apply automatically unless it is adopted, right? Number 2, assuming that it applies, there is no provisions under the rule, and there cannot be a provision under this rule. At least according to him, there is no provision that all this the candidates for the purpose of the training
matter.
can be sent in the provision of 2023, even if it's assuming that it applies, right? Because it is for the appointment of the post, right? It is not for the candidates
Not for-
who are want to be sent for
only for
training.
Only for.
These are the legal issues.
Lordship. Here, Lordship,
Factually, we are not interested.
but Lordship, as per Honorable Court's direction, and in a case, Lordship, we have set it in our second affidavit. That Honorable High Court has directed us to follow the process, Lordship. That's
What
why,
process?
Lordship.
No, that will, the order of the court will come later. What is your argument on these points which he has raised?
Lordship, we are adopting
He
the,
basically has the legal issue.
Lordship, we launch-
Actually, they have been sent without there being any invitation, right?
and Lordship,
Now, as per according to you, the petitioners were selected by the secretary himself
yes,
without involving the other stakeholders or the officers of concerned departments. Now you have properly have you issued the advertisement?
yes, Lordship.
By
properly
issuing
selected,
advertisement and entrance by following which rule? 2023.
Lordship. Lordship, we are
Following which rule? Anyway, you have
My from the division side there Assam land some units additional to they are being applied in the kindly have look to the advertisement.
No, no.
Rules
Mr.
governed by
Sikar,
Assam Survey and Settlement
me-
Training Rules 92
will
laws.
come to you. You are for respondents,
Fine.
private respondent.
Private.
Assam Survey and Settlement Training Rules 1990.
That you have applied. That you have applied.
Yeah.
Then it's a matter of interpretation of this rule. So, so as that you have applied that rule and in terms of that you have issued an advertisement and the respondents, private respondents have been selected. Was there any entrance exam?
Lordship, there is a written test and Viva was Lordship.
Okay. As per the 1991 rules.
1992 rules.
Okay.
1992 rules.
Why you are 92? Why you all are saying 1992?
My lord, in the actually
The
91
rule which you
rule
have
was my lord
There are-
91, but they have adopted 92, that's why 92. my lord.
There are 9.
No, no, it's rule, these rules may be called the Assam Survey and Settlement Training Center Rules 1991,
Hello.
page 3.
But in the body, my lord, they have written the
It was
government has
issued-
written 92.
Issued in on prefaces of 1992.
My lord,
The notification will not do, name of the rule has to be
my lord, 91.
Maintain.
my lord.
91.
Right.
Yes,
And Lordship, we have Annexer 1 Lordship. Kindly peruse my affidavit Lordship filed by the Sujit Baglari, Secretary BTC Lordship. Kindly, we have Annex 1 notification Lordship. Of BTC Lordship.
page
Page Lordship, running page, I think 67, if I am not wrong.
67.
67, Annexer 1. Affidavit filed by Sujit Baglari.
Notification.
No.
Page 153, my lord, running page.
153.
It is hereby, can I read Lordship?
153. It is hereby notified.
It is hereby notified. 28 October 2010 Lordship. It is hereby notified that consequence upon creation of the Bodoland Territorial Council with effect from 7 December 2003, after bringing necessary amendments to the sixth schedule of the Constitution of India, by the sixth schedule to the Constitution Amendment Act 2003, number 44 so and so, and the Constitution so and so, the Bodoland Territorial Council by virtue of the Memorandum of Settlement 2003, reached between the Government of India, Government of Assam and Bodoland Liberation Tigers, read with Government of Assam Office Memorandum so and so. I am reading since as per Rule 5.1 of the Memorandum of Settlement 2023, the Bodoland Territorial Council shall have the legislative power in respect of all the transferred subject. Therefore, the Bodoland Territorial Council is competent to make laws of its own as regards to those 40 numbers of transfer subjects, provided that the laws made thereunder shall be submitted forthwith to His Excellency the Governor of Assam, and until assented to him shall have no effect. It may be further stated that under subpara 1 of para 12 of 6 schedule to the Constitution Amendment Act 2003, in connection with the application of the Act of
Very difficult.
Parliament Legislature
May I
of the
provide a
sixth
type copy,
schedule
my lord?
autonomous
Type
districts,
copy.
the autonomous region in the state of Assam, the district of the
All right, difficult.
My lord, for me also. my lord.
Yes.
Lordship. Districts and autonomous regions
So
in
in
the
view of
state of
the
Assam,
above,
which,
until unless the Bodoland territorial areas annexed in any or pending approval, we will be saying.
so in last paragraph is the important. So in the view of the above,
passed by the Bodoland Territorial Council legislation is to the transfer subject. The existing text rules except the reservation of post and those which are explained. Yes,
Yes, Lordship.
who is disputing this?
Yes, Lordship. That's why we are following the, adopting the rules framed by the state of Assam. And Lordship, in earlier, one repetition WPC number 8364 of
Let us assume
2018.
that this is applies.
Lordship,
Under which provision you have selected this? Issued the notification and issue.
1992, 91, Lordship.
91 is no dispute. He's also saying it's applied. What he said is 2023 is applies. It doesn't apply because it has been framed after the
After the
establishment
creation
of council.
petition.
All right. Anyway, by this notification, let us assume that it applies. All right.
Yes.
So what is the provision for sending the candidates for training under this rule?
No specific provision, but we are trying to make it transparent, Lordship. Earlier, candidates who. were
Have you
selected-
not invoked rule 1991 rule?
Yes, Lordship.
Which rule you have applied?
1992 as per our instruction, Lordship, 1992.
So why we should go into then 2020? Since you have not invoked rule 2023. Are you saying this 2023 has not been invoked? Has not been invoked for sending a candidates to the training, for training?
We all.
Am I clear,
Yes,
madam?
yes, Lordship.
Hmm.
But we are trying to make it transparent, Lordship, and through selection process, Lordship.
Although it is not transparent, you are trying to make it transparent.
It is transparent, Lordship. We have advertised properly and selected as per.
Madam, I am not on
Earlier
that.
one is, no.
Whether you have invoked rule 2023.
No. So earlier we.
If you have not invoked, it's matter ends there. Yes. It's no question of invocation, invoking the rule 23, 2023.
That is 92. That has been applied in our case also. Well, only difference is that the 219 candidates were selected without any adoption of transparent procedure. There is an order of this
No,
court.
I'm admitting that these rules, I mean, what they have said, I am not clear, but then whether rule 23 has been, 2023 has
no,
been
no,
invoked or not.
No, my lord. The earlier rule, whatever there, my lord,
Why you are
that,
saying
that has been applied.
I'll advance
My lord.
argument on this point. Why they have adopted.
That, my lord, only my lord, these 92 rules, my lord, they have already referred. Rule 20 says that for admission into each course, the director will invite application from intending candidates.
Yes.
My lord, this cannot be exactly followed because there is an order of the Honorable Court. My lord, I have annexed in my IA. My lord, there was some instances that my lord randomly picking the candidates and they are sent for training. My lord, kindly have a look at my IA. The order dated. Order dated, my lord, 6/12/2018 in my IA, my lord, page 171.
Why you have not filed affidavit?
My lord,
When you were hearing it for to which case?
my lord, my lord, IA number 2768 in WBC number 2785. My lord, we are insisting on for vacating the interim order. Therefore, my lord,
No, we are for final disposal.
my lord. So, my lord,
Page.
my lord, page 171, annexer O. Annexer 0, my lord.
171.
171. Relevant portion at page 188,
17.
171,
Relevant person is.
at page 188. It is order dated 6/12/2018. Lordship got it?
After he learning council parties on the consideration. Not to send recommend candidates for 6 months.
My lord, last line is important, my lord.
Training in the Assam survey and settlement rules.
Without any open and transparent selection process. Because of this, my lord, we followed these 92 rules, but by way of transfer. My lord, transparent procedure.
No, otherwise also, you don't have the stamp of the code. If you have followed rule 20, I thought you have not followed this. So you have, according to you, you have followed to 1991 rule.
92.
Supported by the order of this.
Of this court.
All right.
This
So
is
what about his, the note 1?
Note 1, my lord, so far the my lord 6 schedule, my lord. My lord, 6 schedule, my lord.
District council.
My lord, district council, my lord, my friend has already read out the notification dated 20, that till the.
What she has read out is not relevant. It is about the 2000 application of 2023 rules. What she is trying to say is, as per the notification, until the time the council makes some rules, the existing rules so and so will apply.
Apply.
That is the notification.
Yes, my lord.
There is no dispute.
My lord.
And he's also not raising all this thing.
My lord.
But now then it ultimately it boils down to the interpretation of note 1. Note 1.
Note 1, my lord.
You saw him, note 1.
Rule 23, my lord. Our selection is not on 23, my lord. My lord, this is not at all applicable in, my lord, note 1 is not applicable, my lord. When there is an, my lord, the High Court order to go, to initiate process through a transparent by way of advertisement and
Page, what is the page?
my lord, at page 11, my lord, in the
Page 11 bottom.
page 11, my
type,
lord, bottom.
type copy.
This is part of which rule?
This is by itself the 91 rule, my lord. 2091 rule, my lord.
No.
There is a rule 23, my lord. Rule 23.
My lord, this is in the light of this judgment of this honorable court, this should be ignored, my lord. And this is not inviting the transparency, my lord.
Are you saying that it has to be read down?
My lord.
Are you saying it has to be read down?
Yes, my lord.
How?
My lord, in the light of the Supreme High Court decision, my lord, there is a direction.
Are
of
you,
this,
in that case, are you agreeing to his submission?
my lord, how I can be, my lord?
Then,
My lord,
simply, how can you read down the provisions of the rule?
my lord, candidates deputed by the state, district council, public and private taking enterprise bodies, private individuals seeking admission as private student, uncertified recruiters working against permanent vacancies. My lord, here in this case, my lord, they are unable to say on what basis they were forwarded, they were recommended. They are totally silent. Even we go by this, my lord, how their case was come up, my lord.
What do you mean by even go by this rule?
My lord, this is, my lord, candidates.
See, Sir, I'll tell you, what he is relying is that since this is a district council, BTC is a council,
No.
BTC,
My lord,
right?
my lord.
BTC has sent these candidates for a training. Therefore, by applying this note 1, which
Right.
explains
My lord.
that no entrance examination is required. This is what he's saying.
Absolutely, my lord, wrong, my lord. BTC has not taken any resolution in their respect, my lord. BTC has taken resolution to go for advertisement and selection. That was the resolution. How even the BTC has not taken resolution, how their name can be recommended?
Wrong, it's not a question of, it says candidates deputed by other state district councils.
My lord. My lord, the BTC is the my lord, absolute authority there, my lord, to take decision about the BTC, my lord.
Yes.
That given
So that
power
is
has been
what
given.
he's saying.
BTC has not taken resolution about them, my lord.
It's not a question of resolution, it's a question of deputy sending them.
No, no, how they have sent, my lord, that is also not record. That is also not on record, my lord. They have not sent, my lord. How they can be sent, my lord? How they can be sent, my lord? When the BTC has not taken any resolution. Absolutely false plea, my lord. My lord,
It's
kindly
not
have a look
false
at.
play, it's an interpretation of this rule.
My lord.
Sir, I want you to make your submission on the interpretation of this rule, not one.
My lord, question is, my lord.
Maybe false, maybe correct, maybe true, we are not on that. Lee will consider,
My lord.
what he has said
Yes, my
is
lord.
that this, because of this note one of the rules, since the BTC has sent the petitioners, no examination, entrance examination is required, therefore it is legal. That is what he's saying.
No, my lord.
You interpret this rule. How this rule applies?
My lord, this
In
rule,
what situation?
my lord, the situation is that,
I think, Mr. Sikdar, you need to go through this properly.
my lord,
I'm sure it happens. It has taken you by surprise.
my lord,
You need some time.
my lord, my lord,
Reflect on it.
my lord.
That is his submission. Other, if you interpret, it is the interpretation of note one only now. Now, after hearing the, Mr. Sikdar,
My lord.
after hearing the state council, I mean the BTC, there's no dispute regarding the application of the rules, including the petitioner.
My lord.
Rule 1991 or 92, it applies.
My lord.
Only interpretation is, there's no dispute that as per Rule 2020, it has to be, application has to be invited,
My lord.
right?
Yes, my lord.
It means advertisement.
I agree
And
also.
the procedure is also it's to be followed, entrance exam, whatever.
My lord.
No dispute.
Yes, my lord.
Only his claim is, since the petitioners are sent or deputed by the BTC, a district council, no examination is required. Therefore, you cannot, I mean, bypass, or you cannot ignore the petitioner who has been sent by BTC as per the note, in terms of, which is in consonance with the rule, note one. That is his submission.
My-
That's the only issue. So it's an interpretation of note one. Judgment, I mean, order can be passed, decided, it can be decided on in 2 pages now. No matter how voluminous your petition is.
My lord.
Next week,
My lord.
Madam,
let him,
Madam, the
reflect.
status quo order may continue, madam.
yes. On 11,
My lord.
all right. Heard Mr. M. Saranya, done counsel for the petition.
And for 1 to 4.
Yes. Record all this. After arguing the, after hearing the matter, at some length, come up.
Wonderful.
It is. It appears very impressive that the issue to be determined as to the interpretation of note one of Rule 23 of what is called Assam.
একটু আসেনি কেন আমার লগত নাই লাগিব
Assam Survey and Settlement Training Center Rules 1991. Next matter. Is Mr. Serenia, Learned Counsel for the petitioner, has submitted that in view of the note one, comma, there is no requirement of entrance exam. Therefore, the deputation or sending of the petitioner for training by the petitioner is in consonance with the rule of implement. Mr. Sigdar, Learned Counsel for the respondent number,
My lord, private respondent.
private respondents. On the pointed query of this court as to how, as to whether the note one would apply if the BTC sends the candidates for training. No, pointed query that would the note one will cover note one of the rule 23, so and so, Act 1991. The rule 1991 would cover the case of the petitioner. Press that he may be given to, he may be granted some time to reflect on the interpretation, proper interpretation of the rules accordingly. Mr. Sigdar is granted 2 weeks time to.
My lord.
2 weeks time.
Well,
Sorry,
status quo, Your Honor.
this matter on 11.
Well.
04/20/25. In the meantime, the status quo is there, interim order is there.
My lord,
Interim order passed earlier shall continue.
my lord,
The matter
Understood.
remains part heart. We'll keep it part heart.
my lord.
Where we spend considerable amount of time.
Well.
Keep it part heart.
In this matter, my lord, the respondent of 6 college issued an advertisement for appointment of
Yes.
various posts of.
Before going to on merit, yes, judgment to that the case is premature lordship.
Huh?
Case is premature lordship
Why?
because director has not taken call.
Taken all.
Taken call, not examine lordship. This is the similarly covered lordship. And another 2-3 judgment with me lordship apart from this.
You are for
Higher education lordship.
higher education.
Lordship.
My lord, that is not the director, I am for the marks, my lord.
Paragraph 6, 7, and 8 lordship.
What do you mean by this?
Lordship, the director has not taken. Lordship, may I read the paragraph 6 lordship?
Not read, not read it. You just tell us why.
Because the governing scheme is governing body recommend the assistant professor lordship recommend to the
Response number 6.
6 to the director. Then
Yeah.
they have silenced lordship. Then before director taking any call, as per this, there is no finalities there lordship, and that's why it's a premature. That the court is held.
Let us see the rule, which,
No, no,
where
lordship,
is
lordship.
the requirement?
Lordship. 498.
Lordship, 490, 497, Lordship. 5. Mode of recruitment, Lordship. 2, Lordship. The post of lecturer librarian shall be made by direct with a prescribed qualification for open and leading successors.
The Assam College Employees Provincialization
Lordship.
2010.
10
Is
rule.
it apply? Is it
Yes.
applicable?
Yes, yes, yes.
Your selection is under this rule.
Yes,
My lord, my question is this, my lord, here.
No, whether this is under this, your
Yes.
selection is under this rule.
Yes, Lord.
Is it under this
Yes,
rule?
Lord.
Assam College Employees Provincialized Rules 2010.
Yes, Lord.
Yes. So which rule?
Lordship, 5 rule 2, Lordship.
Ah,
Uh,
for the post of lecturer, librarian, appointment shall be made by direct recruitment with prescribed qualifications to open it including in respect of grade 3 and grade 4 post, the list of police shall be. So,
Then 7, Lordship. Direct recruitment, Lordship.
rule 7.
Lordship. All appointment,
No, no, no.
either by the direct or by the promotion, shall be made by director on basis of recommendation of the governing body based on the recommendation of the selection committee. The director shall communicate the order within 30 days, Lordship.
Huh?
Within 30 days or communicate, Lordship.
Where it is?
Lordship, B, Lordship, 7B.
All recommended and direction by commission shall be made by the director on the basis of the combination solution. They shall communicate his orders within 50 days.
Lordship. This is the scheme, Lordship.
So,
In this case, Lordship, the director has not examined till that because the interim order, they could not proceed, Lordship. And the order, this order and other orders, this is till director exam, this is attain no finality, Lordship. And that's why premature. This order says that, Lordship. And other 2-3 cases, I have the same thing, Lordship.
are you saying that even if the selection is made, the
Lordship.
director has to examine?
Yes, Lordship.
Rule doesn't say.
No,
It's
no.
an issuance of appointment order.
That's why in the judgment, Lordship,
The all appointments either by shall be made by
App-
director,
Lordship,
and the director will communicate his orders within 30 days.
Lordship.
Obviously, when the selection
Lordship,
recommend,
That's why I read out, want to read out paragraph 6, 7, and 8, Lordship. That's it, everything clear, Lordship.
before the government shall make an assessment of likelihood.
That's- May I read this paragraph 6 and everything is clear, Lordship. 10 will go, Lordship. Everything will be clear. I will read the paragraph 6, 7, and 8. Thereafter, proceed, Lordship. Having noticed the scheme of
Method of
the
recruitment shall be made
selection
in
of the
manner
post of
prescribed.
principal.
Direct recruitment, all
Lordship.
precedents shall be made on receipt of police verification. These are procedure. Then
Lordship, this aspect of the matter, Lordship, everything is considered here. That's why I'm saying, Lordship. The matter was gone into the court, Sonali sessions as it was held that until the director grants approval or selection process, no final decision can be said to have been in respect of the selection. No definite,
Which one?
Lordship, paragraph 6, last.
Having noticed the scheme of selection posted principle in the provincial, what is admitted in the
No
the selection process has not yet attended. It is only when the director accords approval to the recommendation.
No definite cause of action.
With greatest respect, I don't agree.
My lord, in fact, my lord, they have, in the Blue Moon, my lord, earlier, my lord, we have filed a case. At that time, my lord, the private respondent was not better party. If you also see the order at page, my lord, 39, at page 141. My lord, this honorable court disclosure of the deed, same, my lord, matter, directing us to array the private respondent as a party and then file.
Press.
My lord,
You have phrased a file.
yes, accordingly, we have filed it, my lord. Now we have added the private respondent party. Here, my lord, what happened? The Gurucharan College Silchar issued an advertisement for a post of assistant teacher and librarian. That is, you will also find at page 54, my lord.
So why, no appointment has been made.
No, my lord, first thing, my lord, the director
Appointment has been made or not?
No, because of the,
my lord, director cannot scrutinize the marks given by the selection committee.
No, the appointment has been made or not?
No, appointment has not been made. They have selected already, my lord. I have come against the selection.
No,
That
there
is why
is
this.
any order?
Huh?
Any order?
Yes, interim order has been passed. In earlier case also, interim order was passed. That is why, my lord, they.
Staying the appointment?
Yes, staying the appointment.
Yes.
That is there. They directed not to fill up the post.
Okay.
Earlier also it was there.
Yes.
Then we filed a place, and in the place also it was. The order 18,924, my lord, in this case.
Yes.
My lord, here, first I shall say, my lord, that the difference of points is 0.04 between the two candidates. My lord, what they have submitted. Here, advertisement was issued, it is page 54, my lord, regarding various, we are, my lord, petitioner as well as the private respondent 11 and many others, my lord, applied for the post of this assistant professor, Manipuri, my lord. Now, if your losses comes, my lord.
No, you are challenging that there are two mark sheets.
Yes, 2 marks is also, my lord. That is also, my lord, they are liable to penalty, my lord, here. Under the RTI Act, section 20. My lord, how they can give a false mark sheet, my lord? If it is not a correct mark sheet, how they can give it? Then a type copy has been given. My lord, normally, it cannot be typed, my lord. Normally, it is handwritten, my lord, that marks are given at the selection.
No, what is your grievance? In view of these discrepancies in the mark sheet?
That is one, my lord, but otherwise also, I have not been given the marks for the period I have served as a lecturer, and she has been, other side has been given extra mark, my lord. I shall, my lord, that point I am giving.
Where is these two different marks?
Yes, I am. So, Lord, you'll see, my lord, 95, my lord, first. Lord, this is the provided to me, my lord. On the basis of the RTI, my lord. If you also see, regarding provide information to RTI, it's so and so, so and so. SPIO come deputy director, DAC so and so, so and so. With reference to above, I like to receive information for the following. A photocopy of the company statement is given and enclosed herewith as Annexure 1. Individual marking statement which is confidential and classified document cannot be provided due to want of unanimous consent of the concerned members. Photocopy of the application so and so, so and so. So and so. Now, my lord, if you also see next page 96 onwards, that is the, my lord, mark sheet provided to me. Here, my lord, the person who were absent, my lord, they have been also been given the marks. Huh?
Sir, you kindly point out what is the discrepancies, what is the
Yes,
difference?
discrepancy there, but now the main mark sheet subsequently given, my lord, that is that page, my lord.
Yours and the respond number 6.
At page 115. Yeah, 100.
This 96 is of what?
96 is the mark sheet given to me, my lord, as per the RTI Act, my lord, direction. How they can give it, my lord? If your lordship see RTI Act, my lord, section 20, if any false information is given, they are liable to be punished. This is not the mark sheet. Here, my lord, all the 000 given.
Huh?
Here, all the, my lord, 000 given, my lord. Here, my lord, many places. 96 and 115, if your loss is considered, there is a lot of discrepancy, my lord.
What are the discrepancies, sir? I would like to see.
Yes, my lord. If your loss will see page 96, my lord. Page 96, number 1, HD so and so. Here against, my lord, the subtotal, they have given 13 against column number 14. Here, column number 14, nothing is there absent. Now, in other cases also,
This 96 is punished by whom?
principal, my lord,
Then 100 and this thing is by whom?
by him itself, principal.
How you have been provided to
That is the, my lord, question. My lord, I applied for that mark sheet under RTI Act. They did not provide. I filed an appeal. Then I filed a second appeal. Second appeal, my lord, as per the second appeal direction, my lord, they have given me this mark sheet, which is not a correct mark sheet, my lord.
principal?
Principal.
Yes, who is for principal?
My lord, first of all, let them come to what is their case. Now, my lord, your lordship may take up.
No, before that, I just would like to know why 2 mark sheet has been provided to him.
But whatever he's saying, these are all disputed question, whether the read court will go into all that.
It is glaringly, I mean, annexed the two different mark sheet. Why?
No,
Just
my lord, I'll take your lordship to that.
Why two different mark sheets
Just one more.
by the same authority?
Your lordship, just see the selection committee, how they have dealt it. That is the crux, they will have to reply on that. Page 2, your lordship, kindly see extract from the proceedings of the emergent meeting of the governing body held on so and so. Resolution number so and so resolved that the selection of M. Nyanga Singh, the only name duly recommended by the selection committee in its meeting held on 2/11/2022 against the vacant post of assistant professor in Manipuri under so and so category. Roster point number 6 be approved and forwarded for appointment as assistant professor in Manipuri, Vice Dr. So and so, Associate Professor, Department of Manipuri, retired on so and so. The principal cum secretary be requested to send proposal with a request to appoint so and so as assistant professor in the Department of Manipuri of this college, along with a copy of the said resolution and all other relevant documents to the kind and of the DHE Assam for consideration. Further to undertake that the concerned sanction post is not subjudice personnel post and not already withdrawn by the government and also not been previously filled up on falling vacant. The principal cum secretary of the governing body
be requested to take necessary steps in this regard. Now, in the next page, your lordship will find
The
Professor-
recommendation is Dr. K. Naman Chand Singha.
yes.
Huh?
Then, my lord, the next page, your lordship can listen.
No, requested proposal with a request to appoint M.
M. Ningaiba Singha. He is the selected candidate.
Against the vacant only name duly recommended by the solicitor in its meeting. Against the name. The provided for appointment is listed. Yes. Okay.
Then,
This
my lord-
paragraph is retirement.
then your lordship may see how the marks were allotted to them. Your lordship will look at page 6.
12, we can do 6.
Your lordship will find
And the single by the-
name of the petitioner, R.K. Tampashena. In teaching experience, she got 0.75.
Hmm.
And the total mark she got 53.53. Then your lordship may skip to the next page. M. Nigamba Shingai, he is the selected candidate. The teaching experience, your lordship will find, he was given 2 marks and he got the total mark 53.57. Therefore, he was selected. And now the case of the petitioner, my lord, your lordship will find that her claim is that he is entitled to get more marks in teaching experience, which she is not entitled. That is her case. Now, I will take your lordship to that point, my lord.
Let me argue with them.
No, his lordship has,
No, yeah. My lord has asked you to show why discrepancy in the 2 mark sheets.
there is no discrepancy, my lord. My learned friend is going some other non-issues. These are the crux of the thing, your lordship. He will have to satisfy your lordship to that. You know,
shall-
this is
I
the
shall
final
satisfy that.
result. Now,
Are
his,
you saying, have you filed the affidavit?
yes, we have filed.
No, are you saying that these 2 marks, page 15, the 96 and the 115 are 2 different marks? It is
No,
by
no,
you.
that I did not go to that because the selection committee result is the main. Their grievances, your lordship, look at the writ petition.
No, it's okay. That will, I'm yet to hear him.
My lord, in that
I
case, your
just
lordship,
wanted to know why 2 mark sheets?
but I'll see to that, my lord. In the meantime, your lordship hearing, I'll see to that.
No, my lord,
And my lord,
No.
just for 1 minute.
Apart from this issuance of 2 mark sheets.
Yes.
Different mark sheets.
yes.
Is it contains the different,
Marks also, my lord. Here, my lord, my 2 points are there. First thing, my qualification, my lord, marks has not been given, academic teaching experience. And the rationale 11 has been given more marks, which he is not entitled to. These are the 2 things.
No, 2 things in there, both the mark sheet which you are claimed to be the different mark sheet.
The mark sheets are
What is the
contradictory.
mixing?
Mark sheets are contradictory. Even if we go to the last mark sheet, then also, my lord, I am saying that I have a case. If you also see, my lord,
I just want to clarify.
my lord, if your lordships, my lord, see,
2.53.57. Where is your mark sheet?
yes,
Where is your thing?
my lord, just my lord,
Okay, Tampa.
2 mark sheet, my lord, your lordships must see.
53.53.
Earlier, my lord, they have shown 0 marks. So, for teaching experience concerned. Serial number 11.
0 mark.
Yes.
Then
Earlier mark sheet. Now they have given it 2.
where?
Yes. Column number 11, my lord. If your lordship see at page 98. 98 to 99. My lord, page 97, serial number 9. Serial number 11 mark. If your lordship see.
Ningayaba Sangha,
Zero decision,
teaching experience 2. Huh?
In column number 11, if you also see,
97
serial number 97. Serial number 9
is the respondent number 6.
No, respondent number 11, my lord. Now,
Ningayaba, who has been selected?
is 9, serial number 9.
Yeah.
M. Nibogora Singh.
So teaching experience is 2.
My lord, no, here, first thing you'll also find, my lord, discrepancy.
What about you?
No, this research paper so and so is 0, 11. 11. If you also see column number 11 is 0. You have got it, my lord? You also in column number 11,
Yes.
serial number 9, column number 11, it is 0.
This is of what? Research paper
Research paper, yes.
of respondent number 11.
Yes, that's my 11.
What about you? What about you?
My lord?
What about you?
Yes, I'm. So far, I'm concerned. My is 96, my lord. I have also been given 0.
Huh?
I have also been shown at 0.
So
far, research paper is concerned.
no, this marks
Now,
115 is a consolidated statement of working of the candidate appearing in so and so.
No.
And this is an individual score sheet.
no, but in the research, my lord, if you also see
Is
that.
that not the same thing?
No, my lord, your losses may take these two, my lord, at a time. At a time, your losses may both compare.
It's a comparative statement of marks.
Yes.
And the
Just now, your
consolidation
losses-
is
Your losses may take up, my lord, this one, my lord, that will be better. If your losses take both simultaneously, then your losses will.
no, what is not a different mark sheet.
Those two different.
First one, no. This is in comparative and this is the page 115 is a consolidated mark sheet. Marks is statement.
That was given me to my RTI application, my lord.
That's what I'm saying.
Given to me by RTI application.
These are comparative. And the 115 is consolidation. Consolidated statement of marks.
Yes. RTI application is here, my lord. As per RTI application, they have given it to me. And here, my lord, if you also see, so far, item serial number 9, column number 11, our mark was shown as 0. But in the final, my lord, if you also see, her mark has been shown as 2 in the research paper. Research paper, my lord, they have increased it. 2. This is the discrepancy, my lord. Serial number 9, column number 11. In the 2 mark sheets, my lord, the differences are there. Page 97 and page 170.
97.
97, you will also find in a research paper, she was given 0. Page 97. And in the 117, she has been shown to have given 2 marks.
Where his name is?
M. Singh.
M. Ningaiba Singh.
Yes.
9.
9. Here,
Research paper
2.
0.
0, and here it is 2. So earlier, my lord, in column number 20, it was 18 total marks, and page 97. Now it has been made to 20 in the page 117. It has been made to 20. This is the discrepancy. And column number 19 and 20, these are blank in 97. Whereas in the subsequently they have given it. This is after the interview, my lord. They have supplied me the mark sheet.
No, this 296, 97 is a comparative statement.
My lord.
And the 115 and 17, 15 is consolidated statement.
Well, they give, they now subsequently, they type it out. That is another aspect of matter. But this is the, my lord, same thing. Content is the same, my lord. If they prepare a fresh one, my lord, how they can do it? The mark sheet, my lord, because it is after the interview, they have given me to this market. What is this then? Let them explain, my lord, what is this? Because this is the, my lord, main thing is this was supplied to me by as per RTI, my lord, the appellate procedure order. And here they have shown 2 marks in the column 11, and that is why it was shown to 20 total marks. Whereas in the final they have it was 18 originally. Then it has been met to 20. That is the my lord, that is on the given my lord. And then on merit also I have to say, my lord. On otherwise also I have to say.
What is to be said?
What
is your summary?
Yes, I am sorry. Now, my lord, so far, I am concerned, my lord, if your losses take up page 159 of the affidavit, page 159.
Yes.
Well, seal number 4, my lord, if your losses see. Reference date for acquiring qualification. Candidate has to acquire qualification as on the date of the last submitting application. Eligibility like MPhil, PhD, seminar paper, publication can be acquired and submitted on the date of interview and not beyond. So, my lord, these other things, only, my lord, the qualification, they have to show on the date of interview, submitting application. But subsequent other parts, my lord, regarding eligibility, my lord, we can submit it later on.
Eligibility like PhD seminar paper can be acquired and submitted on the date of interview, not beyond.
Yes. Yes. Now, here, my lord, what happened? The petitioner, this eligibility, my lord, so far the teaching experience is concerned, he, after that also, he was working, my lord. That your loss will find, my lord.
Teaching experience, you have not been given marks.
Yes.
According to
0.75, only 0.75. But this mark I am entitled to. Page 65, my lord. You have noticed this. Page 65. This is additional work mark I should have given. Because this I have acquired during this period. I have produced it at the time of interview. Page 65. I worked in the Nehru College against sanction post from 1/8/21 to 38/22. So this mark has not been given to me.
how much you are entitled for this?
1 mark, 1 mark, Mal. For this, I am entitled to 1 mark. And difference is only 0.4. This I am entitled to 1 mark. This is. And second case, my lord, my. And coming. If your lordship see, my lord, the advertisement, my lord, at page 56, my lord, if you love to see, page 56. Column number Roman 7. Your lordship got it, my lord? The period of time taken by the candidates to acquire MPhil or PhD degree shall not be considered as teaching research experience for appointment to the petitioners. So the period when they got the MPhil or PhD degree, that will not be counted. This is one of the conditions. Then, my lord, your losses may come to page 58, my lord. Page 58, Roman 6. Teaching library, your lordship got it, my lord. Page 58.
Yes.
Teaching library management experience in the concerned subject domain. 1 mark for each completed year of service for acquiring UGC norms as in provincialized government affiliated degree college, libraries of the government institute, higher secondary class of provincialized schools, subject to maximum of 2 marks. And however, if the period of teaching experience is less than 1 year, then marks shall be reduced proportionately. In this case, minimum of 3 months mark to teaching experience will be counted. So 3 months, my lord, 0.25 will be given. Now this is one. Second, then, my lord, your losses may come.
We'll see the records.
Yes.
Okay.
No, just, my lord, I'm completing, my lord. Yes, let me. Page 100, if your losses see, my lord. Just page 100. Application of the, my page 99. This application of the lesson number 11, my lord. At page 100. Column number 5. He obtained PhD on 11/3/19.
Column 5. Category.
Column 5, PhD, MPhil, PhD, HS. He got it on 11/3/2019. And this was admitted by her in her affidavit, which is at page 169, my lord. Just your losses may.
Just tell me what is his admission. If he is admitted, what is to be looked into?
No, the period is given there, my lord, in the affidavit. 169. That is important, my lord. I can show from here also, but she has admitted, my lord. Because at page 118, my lord, it is there that she was admitted for PhD on 31/3/15. And this has been admitted by her in the affidavit. Page 118, my lord, may be seen. First, my lord, 118, M. Nigoro Singho, PhD registration, done on 31/3/15. So this period, when she got the PhD, her teaching experience cannot be counted. That I have shown the notation value. Teaching experience cannot be counted. For the period from 31/3/15 to 11/3/19. So this teaching experience cannot be counted at all, my lord.
Has it been?
Yes.
Has he been provided the marks for the 2015 to 19?
My lord, that is
where it is.
That has been provided, my lord. Because
Where it is.
my lord, they have given 2 marks, my lord.
Let us see which mark will see.
My lord, they have not explained this. Now I shall come again, my lord. Her expense. My lord, as per the she subsequently she worked in, my lord, Pathakandi College, my lord. Page 119, my lord, your lordship may just come up. He worked subsequently in Pathakandi College of Education. Here, my lord, at page 120, my lord, just I am. The college is offering the last paragraph. College is offering two teachers training program by Bachelor of Education, BAD affiliated Assam University, and Diploma of Elementary Education affiliated to SCRT. So and so. So, my lord, this diploma is not affiliated to Assam University. So, any teacher, my lord, who is working as in the diploma course, her qualification will not be counted. Now, I am coming further, my lord. At page 125, you will see. Page 125. Second part, teaching staff, DELD, diploma. Diploma, she worked, seal number 2, AM Nigobanda Sungo, assistant professor. So, she cannot get the teaching experience of this period because this is not a course which is affiliated to a university. And even if it is given, my lord, she cannot get that much, my lord. 127, my lord, just tell us. Page 127. Huh? In the BEd, my lord, what they are showing, my lord. Now, at page 129, your losses may come. For paper 305 session subject is mentioned below. Group A, teaching, my lord, the group A in page 129. Teaching of Bengali, teaching of English, teaching of Manipuri, teaching of mathematics. So, my lord, this period also, my lord, cannot be counted. Even if it's counted, my lord, she will get only. I'm just. Huh? You will get 1.75, my lord. Instead of 2. If you will also see, my lord, page 193. 193, my lord.
Sir, we'll go into.
I have given the chart. That is why I have given the chart, my lord. That is why I have given the chart, my lord.
How much mark, how much not mark, we're not going to that much.
Well,
I don't think so.
No, that is to be considered, my lord, because first thing, so far I am concerned, my marks has not been given. So far my teaching experience is concerned. Secondly, she will not get the marks during the period of doing PhD. Huh? He is not getting that mark. He is not getting the mark during which he done the PhD. That is, my lord, in her affidavit also she has admitted. 2015 to
When did you obtain your PhD?
My lord?
You, whatever your petitioner.
Petitioner earlier, my lord. Petitioner has no dispute so far PhD is concerned.
When did you obtain?
Yes, I'm thinking. 2015, my lord.
15. After that, you had an experience.
Yes.
Teaching. Which college?
My lord, that I have given, my lord. Page 102.
So far as the college is concerned.
Page 102, my lord.
So far as the college is concerned, we are not impressed because it's a language only.
My lord.
Whether it is a diploma,
even if
it has to be college only.
Yes, suppose your loss is considered.
It's
That
a
is why I am saying, my lord.
language.
No, that is why I am saying. Even if that qualification is considered, my lord, then also she will get 1.75. He has been given 2. If your loss is considered.
Where your teaching experience?
102, my lord.
Other DC is.
Ekdam bottom, my lord. Huh?
3 months. Then 3 months. Then 3 months.
Yes, my lord.
All 3 months.
3 months, that 3 months, my lord, will be counted on 2/5. As per
1 year.
my lord.
3 into 4.
That's not.
1 year only.
That's on, my lord. And moreover, that
15 to 17.
then subsequently, my lord, I have
All
always
this-
placed.
4 years you have had the experience of 1 year only.
Subsequently, I have placed, my lord, that I am that will get marks, my lord, during that period. Page.
That has not been given. Teaching experience has no, marks has not been given to you.
Yes, 65. Page 65 has not been given, my lord.
No, you have not been given.
I have been shown, my lord, given 0.75 only. 0.75.
It has to depends on the.
No,
Your teaching is every year you have only 3 months.
My lord,
It's
you are
not
also-
1 year.
No, you are also see, my lord. Even if her, so far, his expense is concerned, even if his, my lord, teaching is Pathakandi College, which is not an affiliated course to Assam University, even if it is counted, he will get 1.75, not 2. That is why this is because difference is only 0.04. 0.04. There is a blue-eyed boy, my lord, they have just selected. That is why, my lord,
Will not, what is the difference? You will see whether the selection process, whether this properly, the marks were given, allotted or given to, awarded to the candidate.
that is the thing, my lord. That is why, my lord,
From that, we'll call for the records, sir.
Hello?
We'll see the record. We'll see the records.
if necessary, my lord, I can give a synopsis, my lord.
No, I'll not keep it per heart. We'll call for the records. If it comes back, we'll hear you again.
I'll just counter saying within 5 minutes, I'll make the thing clear. His submission will be negated.
No, even if you make it clear, he will not be satisfied.
That's
Therefore, we would like to see the record.
yes, that
Whether
record is
the
available.
allegations is correct or not.
Record is available.
Yeah, the records are there. Okay.
But director, because take the first was of this case of because everything can be returned back to the director and the marks, everything, director before director has to apply his mileage mark. Thereafter, he may not be give approval. That exercise has to be done by the director. And every exercise has to be done by.
You assured that
Yes, Lord. Yes, Lord.
you will not appoint her, appoint the private respondent.
But that director was not the rabbi son of it. The court has helped. The director has to.
You have the record,
Yes, I have.
all these selection marks and all.
Yes, the college authority sent the record. That's a record.
It contains the mark sheet, the comparative statement of the marks and the consolidated. Let us see.
Your lordship take it 2 PM because it is now already time.
There are all matters, hearing matters, you are yet to reach the hearing matters. We give preference to the all matters. Your
it's
matter
a
is
matter.
of 2020.
24, but earlier, about 23 matter that was disposed of because.
See, we have yet to reach the hearing. Today's hearing at 2012 matter, 14, 17.
My lord, I will clarify the matter within 10 minutes and my lord, this
No,
importance.
We'll hear it. We'll keep it for her. You retain the records.
My lord, can you lordship take
You
it
give,
2 PM?
or else you
Yes.
place the record. we'll see.
Will Lordship take it?
We'll
2 p.m.
continue, we'll continue at, we'll hear it on again, on tenth. Tenth April.
My lord,
Lordship, I will not be. Then. Available on tenth. When?
my lord, at 2 your Lordship
You are
can take.
for? I am for the private, the selected.
He's a private respondent.
Okay. Your
He's
presence,
the beneficiary.
presence will be required. Then when? Any date before 9, because from 9, 10, 11, I will be out of town.
Let me know 8, my lord, 8.
8.
Eight,
Sir, we'll hear you.
I think director from the hearing the petitioner and the respondent.
That I have considered, which you have.
So far, the legal position is concerned, my lord.
That is
very clear.
That will be the decision after hearing all of them, all of you.
Let it be on 8, my lord.
No. 8, my lord, I have a matter in Green Tribunal at Calcutta on 8. No, it will be too late. Because this post is, my lord, lying vacant for almost 3 years. And my lord, the college is suffering, students are suffering, my lord. There is a very important post of lecturer in the Manipuri language.
After.
And your lordship, take it 2 p.m. hardly, it will take 10 minutes for, I am concerned.
For you, it may be. What's the use if I can deliver the judgment? If it takes 2 months.
No, what my
Right.
learned friend had
We're
said,
supposed to deliver within 3 months. If I cannot deliver it after hearing you at 2 for 2 months, doesn't make a difference. It's better to hear it. Let us not rush. Let us not be, be hasty. If you cannot, if you are, if there's a difficulty on 8, 9, 10, 11, let it go after, Bihu.
we will be out for 8 and 11th, my lord.
11th, I will try to be here.
11th, the last date, my lord.
11th, population. Not Mr. So and so, Indians I have learned senior person, assisted by Mr. And Mr. S. learned senior person, assisted. Yes, Booyah. Vishwas. And anybody else? Hearing to continue on 11th. 04/2020. No, if it is fixing on, since you are fixing on, it'll be with you. You check whether these marks are there. The comparative marks and the consolidated marks. I just wanted to see.
Interim may continue, my lord.
Interim order.
Interim, sir, definitely.
Or if you agree that since the appointment is yet to be made, in view of the judgment, which I have
Let him provide me with the judgment, my lord. I shall see on the on 11th. I shall.
judgment.
Or you can do one.
Because wrongly or rightly,
Yes.
coordinate bench has already
My lord,
passed the order.
And what
Yes,
I,
I can see.
what I understand, my
Relying
lord,
on a 2-3 judgment.
Yes, my lord.
I may have disagreement. If I have a disagreement, suppose if we convince that in view of this judgment, it has to be it is premature. It has to be sent back. In case of my disagreement, I have to refer to the
Yeah, exactly.
Honorable Chief Justice.
exactly.
So I just cannot. Brush aside the judgment also. So kindly share with the judgment. Yes, I've seen it. Three,
So
four
far,
cases has been referred.
In that view, the matter, what I suggest, my lord, let my learned friend go through it. And I have seen it, my lord, it is covered by this judgment. So it can be referred back to the authority. And at 2, your lordship can see.
It will be not be possible.
No, it is छोटा है ना, आप पढ़ सकते हैं.
And make it in that case, second
Yes,
second of
that's good, my lord.
Yes.
that's more than
2nd April.
huh? 2nd April is what? Wednesday. First is what? 1st April. First is what? Tuesday. We'll see on 11.
Obliged.
I mean,
Lordship, hearing this matter, regarding Lordship, his gratuity, leave encashment and pension and pay protection, Lordship, I was supposed to get my instruction, Lordship. Why it has not been released, Lordship? Lordship, may I pray for further a week's time, Lordship? That is 1 week's further time, Lordship. That instruction I have yet to receive, Lordship.
how many days?
Otherwise, Lordship,
Every day you are asking me time.
no, Lordship, it has been pending in the government, Lordship. So from the,
You find out what is there.
yes,
what's
Lordship,
happening.
yes. And the rest they have received, Lordship.
Hmm?
The rest they have received, Lordship.
What you have not received?
Gratuity, leave encashment,
Gratuity, leave engagement, and the
pay and
area of pension, along with the, what is it, the pay fixation. The main issue here is the pay fixation matter. Because earlier.
GIS, GPF and provisional pension. GIS, GPF and provisional pension is getting, Lordship.
No, it's not.
But Lordship, yes.
Or Mr. Council Board of Finance. Mr. D. Upamani.
Yes, Lordship.
Learned Standing Council.
Yes, Lordship. Health and family welfare.
Health and Family is granted further a week's time to obtain instruction.
That may be fixed.
As sought on 17/03/2025.
That may be last
After
opportunity.
1 week, you say.
Any date may be fixed, my lord, otherwise.
You see, after 1 week,
Because
at least after 1 week.
And for
3 dates, my lord.
5 years.
Hmm.
Our board. I was
Yes.
principal of Hojai College. I retired in 2009, my lord. Till date, I have not received any pensionary benefit, no pension, nothing, my lord. Now, what happened in this case, my lord? A departmental proceeding was drawn against me in 2007. And pursuant to that, my lord, Annexure 2 order at page 30, that was passed by the governing body of the college.
No, what happened? What is to be done today?
Lordship.
Huh?
On the last occasion, Lordship, they have provided me the affidavit in reply, Lordship.
Hmm.
So, Lordship, whatever action has been taken, the speaking order, it has been done in accordance with the order which has been passed by the apex court, Lordship. So, Lordship, the apex court was very clear, Lordship, at page, Lordship, 69, Lordship. 69, Lordship, para 7, Lordship.
I may place the facts are very limited, my lord. If you place the entire fact, my lord, it will not take much of time, my lord.
We need letter of 23.
It's a very hard-paced matter, my lord. I am at the age of 75, my lord. I am bedridden in a death condition, my lord.
Hmm.
I have not received anything, my lord. And this impugned order is absolutely arbitrary, my lord. In violation of the order passed by the division bench, appealed by Supreme Court, my lord.
Hmm.
So, my lord, the facts are very few, my lord. If Lordship permit me, my lord, I'm just.
No, what is your stand? Why you are not paying?
Lordship, because there was a
He's
order
not
of,
entitled.
no, Lordship.
Huh?
No, Lordship, there was a inquiry report based on which Lordship we had passed the order, Lordship, the impugned order. Lordship may kindly come to page 69, Lordship.
Just wait, you be wait some minute.
But
In fact, sir, is small wires. Page 69.
Yes, Lordship, this is the order, Lordship, which starts from, Lordship, page 67, Lordship.
Hmm.
Page 69, Lordship, para 7, Lordship. May I read, Lordship?
Yes.
It is directed that the appropriate action as per law be taken by the disciplinary authority appellate authority of the respondent based on the findings returned in the inquiry report within 2 months.
Yes.
So the apex court have, Lordship, accepted the inquiry report, Lordship, and directed us to Lordship to act upon within 2 months. Lordship, thereafter, Lordship, this order was issued, Lordship, the speaking order, Lordship. We have given him a chance, Lordship. We have showcaused him, Lordship. He has given his statement and everything, Lordship. Considering everything, Lordship, on 7/10/2023, we have passed this speaking order. So against which, Lordship, he has come before this court. And Lordship, in our affidavit also, we have stated, Lordship,
So you have been given an opportunity.
yes, Lord.
Okay.
Was given.
How you are aggrieved now?
Yes, ma'am. That's why I'm saying, my lord, I'm
But
placing
that
the
is
fact.
gone. You have complied as per that you have taken action.
Yes.
And then at the same time, by this order, the petition was given a liberty to approach if aggrieved. So
Yes.
whether this is, it's not question of whether in accordance with the Supreme Court or not. Right?
Yes.
On its own moral merit, as per the direction of the Supreme Court, you have taken a decision.
Yes.
On its own merit, he has put, challenged the order.
Yes, Lord.
You are not questioning, there's no bar.
Lordship to
What
challenge.
you are trying to say is, as per the Supreme Court, you have done it,
Yes,
action
Lord.
has been taken,
And
therefore,
Lordship,
there
it-
cannot be any wrong.
Yes,
That is
Lordship.
what you are saying.
Yes, Lordship.
No. Supreme Court simply say, in the basis of inquiry, you take an action.
Yes.
If he is aggrieved, he can come back again. That's why he has come back, he is aggrieved.
Yes, but the speaking order, Lordship, that we have passed, Lordship, it is in compliance otherwise. Lord.
It's not a
And
question
he-
of compliance, non-compliance, it's okay, nobody
Yes,
is
yes.
disputing it. You have taken an action, he is aggrieved now,
Let him
that's
submit.
why I'm asking.
Yes.
No issue. Yes.
Madam. Now, order of dismissal was passed, Lordship, kindly see page 30.
On the basis of the Supreme Court.
No, initial, I'm submitting from,
No, no,
no, my lord, whatever has been submitted, that is not the correct position, that your lordship is not getting it, my lord. The issue actually involved here, my lord. What happened, I'm just submitting, my lord. I was dismissed by managing, governing body of the college. I came to High Court, single bench, dismissed my writ petition. I went to division bench. Division bench has categorically held that it was a government college, therefore governing body did not have disciplinary power and nor did they have power to dismiss me. It was set aside. Direction was given to the director. You being the director, you are the appointing authority under the act. So you hold an inquiry, de novo inquiry, and you take appropriate action. 6 months time was given. Against that order, both the sides, we also went to Supreme Court and the authorities also went to Supreme Court. Now, while the matter was pending, they placed for the first time before the Supreme Court, pursuant to the division bench order, we have already conducted an inquiry, and this is the inquiry report. Now, Lordship, can you see the division bench, Supreme Court order,
No, we
madam?
are not questioning now. Supreme Court say, what says on the basis of the inquiry report, you
You
take
do.
an action.
You take an action.
Action has been taken. What's wrong there?
Yes, madam, I'm coming to that.
Come to that.
Yeah, yes.
Let us not go back to all those.
Now, that impugn order, Lordship, can you see?
Page.
Impugn order is 77, madam. All this fact, my lord, that have been decided in the speaking order. Now, finding part, Lordship, kindly see page 78. May I read it, madam? Accordingly, has your Lordship got it, madam? Accordingly.
Yes, yes.
Correct. Accordingly, the inquiry officer submitted the necessary inquiry report dated so and so, whereas as per rule so and so, resignation from the public service or dismissal or removal from for its misconduct, insolvency, inefficiency, not due to age or failure to pass a prescribed examination, entrance for forfeiture of part subject. Hence, as there is no scope of reinstating the incumbent as per the Honorable High Court order dated so and so, the dismissal order has already been passed by the governing body resolution number so and so, as governing body is authorized to determine the discipline and conduct of teaching and non-teaching staff of a college as per Rule 21 of the so and so rule, as the period of dismissal and suspension falls under the transit period between Assam College Employees Provincialization Act so and so and rules framed thereunder in the year 2010, namely so and so so and so. After careful examination of the inquiry report and the record document submitted, including the show cause reply of the petitioner, that is Sri Anjan Kumar Bhattacharya, I am of the considered opinion, it's an opinion, my lord, that Sri Anjan Kumar Bhattacharya was dismissed from service in accordance with the provisions of law and not entitled for any pensionary benefit. Now, the director is saying, no. What governing body has done, that in my opinion is the correct thing, he is not entitled for anything. Now, this honorable court has categorically held, the division bench judgment, that governing body had no jurisdiction. So it was set aside, it was sent back to director. Now, director, while passing the order, my lord, saying that whatever governing body was done that 2008, my lord, that is, in my submission, my lord, this is in violation, not only violation, my lord, this is contempt of court, my lord. Apart from illegalities, my lord.
What about Supreme Court?
Supreme Court has said, you have already conducted an inquiry, as we have said, my lord. You complete the inquiry.
Yes.
Director is not saying anything, my lord. Director is.
Where is that?
My lord,
69.
69.
Yes.
67 is the order, my lord.
Give the judgment order simple.
Paragraph 6, my lord, it is rather surprising to hear that no action has been taken by the respondent after receiving the inquiry report. In the year 2019, Learned Counsel for the petition respondent state assured that the court that immediate steps will be taken so and so. It is directed that the appropriate action as per law, be taken by the disciplinary appellate authority for the respondent based on the findings on the inquiry report within 2 months from today. Needless to state that in the event the department proposes to take any action against the appellant, principle of natural justice shall be adhered to, and he shall be afforded opportunity so and so. The appellant shall also be entitled to seek appropriate legal recourse if agreed by the decision of the so and so. Normal order, my lord. This is on the basis of.
After this, you were provided opportunity.
I was given forwarded the inquiry report for the first time, saying that you give your representation. But Lordship may kindly see what was the observation of the division bench. Lordship, kindly see.
Oh, we'll not go into it.
Division bench has.
See, so all of you approach the Supreme Court. Supreme Court, there's no stay, nothing.
Nothing, yes.
No action was done. Even then, no action was taken, considering that directed the authority, disciplinary authority to take action on the basis of the inquiry report.
Inquiry report. Yeah,
So
yes.
action has been, you have been provided an opportunity, done. Now what we have to see is, independent of what has been decided by this court, whether on the basis of inquiry report, whether the dismissal, by the impugn order is
yes
bad or not, we'll see that.
Yes, my lord. That's why. Why?
But problem is, that's why I'm saying, prior facie, you have not decided the by this impugn order, you have not decided based on the inquiry report or something. You have not taken the decision.
Yes, my lord.
You are simply saying the dismissal by the selection committee or whatever
Division.
is as per the rules, and therefore it was correct. You have upheld the decision of the what is the subject that is gone. You have to take an independent decision as a disciplinary authority on the basis of inquiry.
Exactly.
Lordship, that was been stated in the last paragraph, Lordship.
So,
After careful examination of the inquiry report and the records documents submitted, including the so-called reply of the petitioner, that is Shri Anjan Kumar Bhattacharya, I am of the considered opinion that Shri Bhattacharya was dismissed from service in accordance with the provisions of law and not entitled to any pensionary benefits. After careful examination of the inquiry report, Lordship. So inquiry report was considered, Lordship. And the records, documents submitted, including the so-called reply of the petitioner.
Now, my lord,
inquiry
it's a-
report has submitted necessary inquiry report that it shows. So, thanks. Where is this person? You have to decide on the findings of the inquiry report. You have just paraphrased the inquiry report and you have agreed that was dismissed from service in accordance to provision. Either you have to dismiss, you have to impose on the basis by giving a justification to the inquiry report.
exactly, my lord.
What is this?
And dismissal cannot be done, my lord, as per
Was
the,
dismissed from service in accordance to provision. What is this? Very, very cryptic.
my lord, dismissal
But
cannot be
sending
done
back-
because I have retired. In Supreme Court judgments are there, my lord. After a person retires, my lord, there cannot be an order of dismissal. That is the reason, my lord, director has refused to that order so that I don't get any pensionary benefit, my lord. That is the reason, my lord. Dismissal order cannot be passed now, right now, my lord, because I have retired in 2009. To overcome that situation, my lord, director says that I am of the opinion as a
Again,
law.
Supreme Court has said, when is the order of this Supreme Court?
Supreme Court, my lord,
When it was passed?
Lordship, in
67.
2019, somewhere
67 order was passed on 20th July 2023, my lord.
23, Lordship.
23. So, conscious, you have retired on.
I have retired in 2009.
9 itself.
Huh?
2009, my lord.
Supreme Court was conscious.
My lord.
Supreme Court was conscious that point of time. It was within the knowledge of the Supreme Court. You have
You know
retired
that
in
what
2005.
happened, my lord. I was not in the earlier round, my lord. I was not.
Whatever may be.
My lordship, can
Wrongly
you-
or rightly, this has been ordered, Supreme Court is directed to take a decision by the disciplinary authority on the basis of the inquiry report.
my lord, there is another very,
Privacy you have not taken.
my lord, another vital aspect of the matter. Lordship, you can see page 54, my lord.
Hmm.
Another vital aspect, my lord. I'm taking two aspects of the
Please,
matter.
please. Hurry up.
54, my lord. Lordship, can you see?
54. What is there?
And 54 is the direction of the division bench.
It's
Lordship, can
okay,
you
we
see?
are not going into.
No, Lordship,
this.
can you see, my lord? 16, one small paragraph, my lord. That in view of the matter,
Director,
the director of so-and-so to hold a de novo inquiry into the matter and pass appropriate order in accordance
It
with the
has
law.
been
within
passed,
6 months.
challenge.
Now, Lordship, can you see? One aspect,
This
my lord.
bars with the order
This
of the Supreme
Supreme
Court.
Court, yes.
I'm coming to that, my lord. Supreme Court, my lord, can you see? De novo inquiry. What does it mean, de novo inquiry? De novo inquiry starts with the show cause notice. My lord, no show cause notice was ever issued to me. No inquiry was ever held, my lord. I was
Have you
not
challenged,
my lord.
are you challenging?
now I'm challenging, my lord.
inquiry?
After this order is passed, I'm challenging now, my lord.
No, you
My lord,
cannot.
disciplinary proceeding, I
You
have checked
cannot
now.
challenge the inquiry now.
My lord, inquiry report I have challenged. my lord.
Once you have accepted the Supreme Court and you will have to accept.
Supreme Court has
Supreme
passed.
Court says to take a decision
As
on
per-
Based
on
on
the basis of the inquiry report.
Correct, my lord.
I agree. Privacy you have not taken on the basis of the inquiry report. Your decision is on the basis that the selection committee has rightly dismissed you.
Governing
That's all.
body. Governing body, my
So
lord.
what is to be the governing body?
My lord.
Lordship, but it says that we have considered the inquiry report.
What inquiry? This is not a way. What is the anything on the merit of the inquiry report? What does it indicate?
Lordship,
Simply you are say paraphrasing those words of the inquiry officer and you are just saying. And last line is rightly dismissed. What does it mean? You'll have to take independent decision as a disciplinary authority on the basis of the inquiry report.
Lordship, we will take that question, Lordship, because
Huh?
the logical thinking was that, Lordship, we have complied with since there was a direction to consider and that.
Not consider. You have to take a decision on the basis of the inquiry report.
Yes.
There is a certain allegations are not proved. Some allegations are proved.
Yes, Lordship.
Why you agree, why you do not agree, whether it entails dismissal or any other thing, you will have to. On the basis, we will have to see the inquiry report. and
Otherwise, Lordship, he
decide.
was found guilty of gross misconduct, Lordship.
So,
Yes, Lordship, but that was not there reflected in the.
that case, we set aside this and remand it back.
My lord, I'm on my deathbed, my lord. Lordship, kindly see.
It's very well done. In view of the Supreme Court order, we cannot sit over the.
My lord, I'm just at the cost of repetition. My lord, Supreme Court has said
Because
that.
you have been given a liberty if you are agreed by the decision of the disciplinary authority.
Yes, my lord. That's
So
why
you
I've
are
come, my
before
lord.
us,
That's a yes, my lord.
and you are correct that the disciplinary authority has not decided as directed by the Supreme Court.
This is one aspect of the
So
matter.
they need to look at.
Other aspect of the matter that, my lord, de novo inquiry was never held, my lord.
No, that we can.
That
We
Lordship,
cannot reappoint now.
My lord.
We cannot reappoint that. Of
But-
course, the division bench, but then you went to Supreme Court.
Yes.
Supreme Court has considered your case
No, Supreme
and
Court has said,
directed
my
to
lord.
decide on the basis of the inquiry
No,
report.
Supreme Court, they
Inquiry
said that complying in the division bench judgment, we have held an inquiry. For the first time, it was not given to me, my lord.
Sir, you
And-
go back to Supreme Court then.
No, my lord. No. Supreme Court was correct. They said that, okay, you held an inquiry, complete it.
It's a
2
fait-
months time.
It's a fait accompli now.
And that aspect of the matter, my lord, I am
Only
agitating.
we'll have to see whether the impugned order is.
Now, if
in
it goes
accordance
back,
with
my
the
lord,
law.
Lordship, kindly see if it goes back, they will pass some order again.
So
Dismissal
what is
order,
to be done?
my lord,
They
I have
cannot pass also.
two later judgment, my lord. Dismissal order, they cannot pass, my lord. Your lordship can observe this, my lord. I am placing two decision, my lord, latest decision. Once a person is retired, my lord, the employer-employee relationship is severed, and at any case, my lord, dismissal order cannot be passed. In that view of the matter, my lord,
Is it
any
so?
order they pass,
Is
yes,
it-
my lord.
Is it so?
There are a number of judgments, my lord.
Is it so?
Yes, my lord.
I have no idea.
I am placing the judgment, my lord.
I have no idea.
My lord. So any other order, punishment, they may recovery and all, my lord, that can be done, but dismissal order they cannot pass. In that view of the matter, my lord, pension I am entitled for. Some observation may be there, my lord.
Heard so and so learned counsel for the petition. Chakraborty
B. Chakraborty.
and Mr. Upamani, learned counsel, D. Upamani, and also learned counsel. List after a week for further hearing. I have indicated to you also.
Yes, Lord.
You also.
My lord.
You cannot raise all those things. But prima facie,
Yes.
it appears it's not correct order. But then you think over it. I'll also think over it.
My lord.
I'll also try to apply, I'll have to apply my mind.
My
We
only
consider-
prayer is that, my lord, some decision is lordship. some
Suppose
relief is given,
if
my lord.
I find
My lord.
that it's not, the order is not correct.
Hmm.
If we satisfy, what is be next?
My lord, in many cases, my lord, court does not relegate to further considering the facts of the case, my lord. If now it goes back, they take another 6 months time, then I have to file a statutory appeal. I have to come and I'll not see the light of the day, my lord. My lord, 75 years old man, I have mentioned in my writ petition, my lord, I'm in a bedridden condition, my lord. And what they have done, my lord? They have given an opinion that GB registration is correct, my lord. Can they do it, my lord? Once it has been held to be without jurisdiction, my lord.
That's why, that's the reason.
Just harassing me, my lord.
That's
Just
the reason, not harassing.
Just harassing, my
There
lord.
must be something more than what you are saying.
Yes, my lord.
We'll see.
No, okay.
Yeah, please, Lordship.
Yes,
Lordship, kindly peruse the order dated 18/2/2025.
20,
18/2/2025.
18-2.
My lord.
Yes,
Lordship, I pray for some time, your lordship. Under process, your lordship.
under process.
Lordship, under process in the sense that they are verifying the documents and all, they're calling for the reports and all, your lordship.
After a week. After 2
week,
weeks.
lordship.
Has heard
Two-
Mr.
any date may be given,
Suresh Income, counsel for the petition. Mr. MS
D. Musahari.
D.
lordship,
Musahari,
Secondary education.
Standing Council Secondary Education. Has granted for that 2 weeks time to obtain instruction.
well, date may be given, can it be on 22 April?
We'll see. 3 weeks, 2 weeks, huh?
I am for response number 5 years.
22 April.
Obliged. Your Lordship.
May I please, Your Lordship? Lordship, this is the case for non-consideration of the petitioner to appoint under the provisions of TF, my lord. What happened, my lord? The petitioners were working as the assistant professor in the Vinesha Bromo Engineering College as Koprajar, my lord.
Any affidavit?
Yes, they have filed, my lord. And what happened, my lord? During, they were appointed initially as the part-time contractual, my lord. And contextual, my lord, in the year of 2017, my lord. And this contextual work has been extended by the department and by the principal with the approval of the director. Lordship, kindly turn to page. Thereafter, my lord, kindly see first, my lord, the page 24, my lord. This is the experience certificate issued by the principal, my lord. And in this certificate, my lord, it is clearly stated that the petitioners were, there are the two petitioners, my lord. Petitioners were working in the college as the assistant professor against the sanctioned vacancies, my lord.
On contextual basis.
On part-time.
Part-time or contextual?
Contextual basis. My lord, part-time contextual same, my lord.
Not
Yes.
same.
Yes, my lord.
It's not same.
My lord, part-time. Generally, my lord, they are.
You have said contextual.
My lord, contextual, my lord. What happened, my lord? Thereafter, my lord, as per the government resolution, my lord.
There's a hell lot of a difference between contextual and.
Contextual, my lord, whatever may be, contextual, whatever may be. Whatever may be.
Not whatever, whether contextual or part-time.
My lord, initially, we were.
There is a difference.
We were contextually
Huge
appointed.
difference, huh?
We were appointed as the
On
contextual
contextual basis.
basis by
That's all.
executing a contract.
Huh?
By execution of a contract. A contract was
It's a
signed.
contract.
Yes.
For how many days? How many years?
From 16 to till the November 8, 2024.
24.
This service was.
And you have been terminated.
I have
I
been.
mean, that has been, your contextual period has ceased.
No, not that, my lord. This is my case.
Hmm.
Not that. I'm coming that.
Let us the contract.
No.
What is this contract agreement?
My lord, contract agreement is not.
Condition.
The contract agreement is not with me, my lord. I
It
have
has
been
to be with you. You have signed that.
My lord, only kindly turn to page 24.
24 is what?
This is the experience certificate. Okay, this is the experience
Not
certificate.
experience. What is your appointment order?
My lord, there is no appointment, my lord.
Then
No, what happened, my lord?
how can you say that if you don't have the appointment order?
No,
On what basis you are saying that you are, what is your appointment order?
my lord, there is no, my lord, my case is not that, my lord.
No, first I would like to know why you are claiming that you are working on the contextual basis. There must be some appointment order.
Actually, what happened?
How you have been allowed to work for contract, on contract basis, even for contract basis without any appointment order?
That is the case, my lord. That is the case, my lord. That is the case, my lord.
So,
My lord, what happened, my lord? In the year of 2017, my lord, we were appointed by execution of a contract.
yes,
Execution of a contract, and thereafter, my lord, they have issued the experience certificate. And thereafter, my lord, what happened, my lord?
the contract?
That was, my lord, kindly see. I'm
You are
coming to
not
that.
going for an experience certificate.
No,
First, we would like to see the appointment order. If not, at least the contract, when you are allowed to serve.
I'm coming to that point, my lord.
Don't, please come,
No.
come straight to that.
No, just a minute, my lord. My case is totally different, my lord.
It's okay, we'll understand. I understand. What you want?
My lord, what happened? That's why, my lord.
What do you want? Tell me. What
My
is
lord-
your prayer?
My prayer is that, my lord, the cabinet has decided to re-engage us under the TF provision.
Huh?
TF provision
Huh?
of the act.
Hmm.
TF provision, my lord, the cabinet has decided
Where is the decision?
that is there, my lord. Kindly turn to page 29,
Hmm.
Annexure 6.
Extra minus of the cabinet.
My lord, subject, re-engagement of the part-time faculty proposed to be re-engaged as the contractual faculty against the existing vacant post in the government engineering college and polytechnics. The cabinet rejected the proposal for the change of nomenclature of the part-time faculty and guest faculty engaged in various polytechnic colleges and government engineering colleges across Assam as contractual faculty. Instead, the cabinet approved the engagement of these faculties, my lord. Faculties, these on ad hoc basis against the sanctioned post in accordance with the principles outlined in the regulation TF as per the extant rule of the applicable for the appointment in the government engineering colleges and polytechnic in Assam. My lord, this decision has been taken. Kindly turn to page 7, my lord. Page 30, annexure 7. This, my lord, this is the submission. There's a data has been submitted by the Director of Technical Education to the Secretary, Government. This is the submission of the data of the part-time faculty and part-time senior instructor engaged in the institution under the Director of Technical Education, Assam. My lord, next table, page 31, my lord. There's the table, there's the 4 table, my lord, annex here with. First table is in respect of the engineering colleges. These are the faculties, my lord, who were occupying the sanctioned post on part-time and contractual. That is at page 31.
Yes.
Table number 1, this is for the engineering college. I am for the engineering college, my lord. My college is serial number 3. Former engineering college at Kukrajhar. They are occupying only altogether 22 of part-time and contractual, my lord. Always similar footing, my lord. 22. Next, my lord, page is the polytechnic. Total faculty all over in Assam in engineering colleges is 165. In page number 31, my lord. Altogether 6 government engineering colleges, my lord, in Assam. And altogether, my lord, 165 contractual or part-time faculties were working against the sanctioned vacant post. 165. Then, my lord, this is the table 2 is for the lecturer working against the sanctioned vacant post in polytechnic. In Assam, my lord, there are the 26 numbers of government polytechnics, my lord. Altogether, my lord, 257. And third one is the senior instructor and junior instructor in the engineering colleges. Altogether, my lord, 6. That is at page 33. And my lord, next table is
whom you are concerned.
I am concerned for table number 1.
Huh?
I am concerned for table number 1.
So why you are taking away all this?
All thing, my lord, why, my lord, I am taking. I draw your attention, my lord.
But it doesn't show that it's a section for page 30.
Page?
Part-time assistant professor, part-time lecturers, part-time senior instruction president engaged in the engineering colleges.
And polytechnics. These are my
Where
concern.
does we?
My concern table is table number 1 at page.
Where is your name?
This is the total of overall.
Total were not.
My name, my lord, my name. What happened, my lord? My name. After that decision, my lord.
So what do you want?
I'm coming to that point, my lord.
Come to that point first.
My comment is that, my lord, they have, as per that policy decision of the cabinet, my lord, they
You
have
are
made
entitled to be.
There was no advertisement.
Huh?
There was no advertisement.
You are entitled to be considered.
Considered, because similarly situated other person has been considered and appointed under the provisions
On ad hoc basis.
on ad hoc basis under the provisions of TF as per the cabinet decision, my lord.
Where is 3F?
TF lordship as per the act.
What is this notification? Release order.
I am coming to the point.
Page 40.
My release order, my lord, lordship will find my release order at page 40. This is the release order, my name and the petitioner's name, lordship will find at serial number 4 and 5.
Nima Basumutari, Anjan Mani Baro. Yes.
These are the 20 persons. They were similarly to the petitioners, my lord. They were all were terminated after taking the decision by the cabinet And after that, my lord, the Secretary of the Government of Assam Higher Education Department issued a letter to the director that as per the cabinet decision, the government is going to convert them to the TF. That letter Lordship will find at page 36 annexure 8.
Huh?
Page 36 annexure 8. After the issuance of that taking of the policy decision by the cabinet, my lord.
No, you have been released now.
No, prior to that, my lord. Prior to release my order, why I have been released, that is I am coming to that. Page 36, my lord, annexure 8. After taking the policy decision by the cabinet, my lord. That is there, with regarding the part-time faculties engaged by the principal DT in the engineering colleges, polytechnics under the government of Assam. With reference to the subject stated above, I am directed to request you to release the part-time faculties engaged by the Director of Technical Education Assam in the engineering colleges, polytechnics under the government of Assam, and request you to submit a formal proposal incorporating the proposed places posting against the name in order to re-engage. My lord, them on ad hoc basis against the sanctioned post as per the regulation TF APSC limitation of function regulation 1951 by the department. You are also requested to release all the part-time faculties appointed by principal, engaged by the principal in engineering colleges, polytechnics under the government of Assam from their respective institution. Thereafter, my lord, director had issued a letter to the all principal. That is at page 37. And after that letter, my lord, the principal has terminated all the part-time and contractual faculties from the Dismissal Engineering College, my lord. My lord, there was 20. Later, earlier, my lord, there were 22. 2 has already themselves released, resigned the job. Only 20 were working and they were all terminated. That is at page 44. And thereafter, my lord, annexure 13, my lord, page 41. This is the appointment letter. This appointment has been made by the government, my lord, the secretary, on 22nd January 2025, my lord. Here, my lord, I am coming to the point, my lord, I am reading. Subject to the discharge without assigning any reason thereof, the following persons are appointed temporarily as assistant professor in Government Engineering College of Assam as per the regulation TF of APSC limitation of function regulation 1951 and personnel department OMs related to the appointment under the regulation of TF of APSC, which remuneration of rupees 1,000 per hour subject to the limit of rupees 72 per month, considering their engagement for a period of 4 months. As per the aforementioned personnel department OM or till the time of replacement of the regular employees, whichever is earlier posted
4
in
months
the...
only.
Sorry,
This is only for 4 months.
Only for 4 months, my lord.
Yes.
What happened, my lord? From serial number 39, that is at page 42, my lord. Serial number 39, bottom one, 255. They were the person similar to the petitioner working togetherly in the Dismissal College. They were all appointed. Similarly, my lord, they were not provided any appointment letter. All are 39 to 55. 39 to 55, my lord. They were Dismissal Engineering College. They were terminated. All name lordship will find at the termination letter issued by the principal at page 40, my lord. Except the petitioner number 4 and 5 and 17, my lord. They were not.
Yes.
considered.
What is your?
No, my lord. I have something more, my lord.
That's all.
My lord, what
You
if
want that you should be appointed as per the cabinet decision in terms of the rule
TF?
3F, as has been done to the other similarly situated. That's all.
Yes,
Nothing
my lord.
else. Yes. What is your stand? Why you have picked and
My lord,
chose?
at the time of scrutiny of documents, my lord, it is seen that the petitioners have not done their BTech in my lord relevant discipline because they were holding the post of my lord in the Department of Electrical Engineering, my lord. Their BTech is from instrumental engineering, which is not equivalent to electrical engineering, my lord. That is,
So they are not eligible.
they are not eligible, my lord.
Any consideration? Or it's an afterthought?
No, my lord. That is, and I have in my affidavit, my lord, I have
Response
also.
number 3.
Sorry, my lord.
Affidavit by response number 3.
Yes, yes.
Yes.
Because My lord, we have to follow the AICT guideline, my lord. Very relevant. The petitioner in this writ petition, the petitioners have,
Para 6.
yes, my lord, para 6.
What if it's done their BTech in so.
After verification, it was found that.
Yes,
Yes, my lord.
if you are not eligible, what can be done?
What happened, my lord? In the year of 17, my lord, 2017, my lord, while we have been appointed in the part-time of Contractual, and the cabinet decision, my lord, cabinet decision only to re-engage them. It is a temporary. My lord, what happened, my lord?
Re-engagement means that you have to be eligible.
Yes, my lord. That's why I'm coming to that. Why I am eligible, my lord.
You are not eligible. They are found to be eligible. You challenge the decision.
My lord, what happened, my lord?
Scrutiny.
What happened, my lord?
What you are claiming is you have been, your case has been ignored while considering the other similarly situated person. They consider a committee in terms of the cabinet decision and found to be your degree is not.
Well, I may be allowed 1 minute, my lord. My lord, what happened what they are supposed to submit before your lordship, they have said appointment has been made on 22nd of January 2025. Decision has been taken on 6th of February 2025, after making the appointment of the other person. And my lord, this is a cabinet decision. That appointment TF has not been appointed. TF appointment has not been made as per the provisions of the law. Can you see the law, my lord?
Where we can say that the decision was taken after the appointment?
Yes, my lord, that is at page 51.
That is a contradictory argument because he
That
is
is not,
seeking,
let me
he is seeking, my lord, the appointment under 3F. Now he is challenging that this 3F appointment is not as per law, my lord.
Yes. That's why they cannot take this decision, my lord. They
6
cannot.
to
Supreme Court
2000
totally barred it.
If my lord, the
My lord,
petition
that
is,
appointment, TF appointment has been made as per the cabinet decision, not as per the provisions of TF of the APSC Limitation of Function Act. TF appointment is always direct. That is minus of the meeting of the committee constituted for the selection of presently engaged part-time assistant professor or for re-engagement under TF regulation of APSC in government engineering colleges under the higher education department as per the honorable cabinet decision 24/9/2024 held on 6/2/2025. This is totally afterthought, my lord. And what happened, my lord?
When's that appointment?
My initial TF appointment has from 22nd of January. Lordship will find at page 41 of my writ petition, my lord.
What is the name of?
Name of the Bineswar Brahmo, it is 39 to 55.
Anjamani Baro.
Anjanmani Guru has not been selected. My lord.
Oh, it says it was reviewed.
No, my lord.
It was reviewed
If
on
I have been appointed
20
then they, my lord, what happened, my lord? I submitted.
February.
Lordship, sorry.
February.
February 6th.
February 6th.
Appointment has
It
been
was reviewed. Your case was reviewed, your application.
no application, my lord.
Your application for appointment has been
My lord,
reviewed.
there is no application, my lord, was called for.
That's the question of
No direct recruitment, no application, no selection, no merit. That is not come, my lord, in the 3F appointment. Cabinet says those are the person 451.
Sir, you have filed an application on 29 January.
Yes.
Have you not?
Yes,
Therefore, they said they have reviewed your application.
documents, my lord. At the time of initial appointment, what the petitioner has submitted.
Page
those
51, application as it was reviewed along with the contractual documents, education documents, 1 and 2. Your application was reviewed. You have filed an application on page 45.
Yes, I
Prayer
approved the,
for re-engagement, 29 January
my lord, I have,
and 6 January, your case was considered.
no, no, that is not that. That
That
cannot,
is there.
that cannot done it, my lord.
Why?
This is the Supreme Court says. Supreme Court says.
What Supreme Court says?
Supreme Court says, if the cabinet has taken a decision, government or department is bound to follow it to impede it. Kindly see, my lord, the 2016, my lord.
If you are not eligible,
Everything, my lord, at the time of the taking decision, my lord.
cabinet has not decided, right? Cabinet has not decided to re-engage even irrespective of those part-time or the contractual lecturer or assistant professor, even if they are ineligible.
My lord, this is,
Cabinet has decided only to re-engage.
yes,
So
re-engage, my lord, at that time, only taking of the decision by the.
you have
cabinet.
filed an application. Your application has been considered, right? Appointment, you are not considered, all right? By 6th of, when the other persons were re-engaged, right?
Re-engage on 25,
25,
22nd.
22nd. Then you file an application on 25 January.
No. I have filed that.
Page 51.
Application has been filed on, my lord, on
Yes,
29 January.
Huh?
29 January.
Anyway, 21 January.
Yes, I'm not seeking.
And they have considered your case on 6th of February. Very prompt.
But they have to select me, they have to consider me prior to 22, my lord. My lord, kindly for the
We'll,
time,
I will consider that.
no, for the time being, my lord.
Heard Mr. So-and-so, learned counsel for the petitioner.
My lord, give me some time, my lord.
What more time?
My lord, I will submit everything, my lord.
What everything? I have understood everything. You are saying that cabinet has decided to re-engage you. All right. Re-engage not only you, all those part-time or contractual lecturer or assistant professor in the colleges, engineering colleges. Now, on the basis of that, some of the similarly situated persons have been re-engaged for 4 months or till the regular appointment is made, and your case has been left out, right? Now, you have filed an application, right?
Yes.
On after the re-engagement of your friends, colleagues,
Yes.
right?
Yes.
And your application has been considered by the authority. Your 29 application has been considered on 6th of February.
Yes.
They found that you are not eligible.
That is, my
Until
lord.
that time you challenge that,
My lord,
you cannot.
my case is, am I select?
Your case is simple. Cabinet has taken a decision to re-engage. Therefore, you are entitled to be re-engaged, irrespective of whether you are eligible or not.
This is the.
Initially, see, it appears,
My lord, see,
at the first glance, it appears to be very formidable, your submissions. But subsequently, when your application has been taken and considered, you are found that you are not eligible. How we know that whether you are eligible or not? And you are not challenged, you have not filed any reply to this.
no, my lord, that.
Have you filed a reply to that?
No, my lord.
They are very clear.
Case is pending, my lord.
Can you not file a reply? Reply to the affidavit.
Then, my lord, I may be allowed to file a reply.
No, I've heard you enough. That's why I said you want to.
My lord.
If you
only
had
of
had you been
next week,
had
my
you
lord.
had you have prayed for initial stage,
My lord, kindly,
we have spent more than 30 minutes,
no, 15 minutes, my lord,
not
kindly-
15 minutes.
kindly-
That's why I said, come to the point.
Yes,
It's a wastage of time.
my lord,
Your matter is very simple. You try to make it jalebi, round and round and round, nothing else.
my lord, I beg.
I have heard you. Thank you.
My lord, I beg.
File an appeal. I'll pass the order.
No, my lord,
Thank
kindly
you.
give me,
God bless you.
give me 1 week time, my lord, I will file the reply, my lord.
Mr.
Otherwise, my lord, my entire life will.
I have heard you. You have a remedy under the law. I'm passing order.
Give me
You could have asked for it. You want the disposal. You want to argue the matter. I've heard you. I have indicated you, knowing that you have not filed an affidavit. Don't you think that,
Well, I beg-
do you think this,
My lord, with apology, my lord,
No,
kindly
don't-
give me
Do you
2 days time,
think-
my lord, only 2 days time, my lord, given, my lord.
there's a, I mean, saying in Hindi, जैसे देखता हूँ उतना बुद्धू तो हूँ नहीं.
So, no, my lord, I never said things like
Don't
that.
judge the person by their looks. All right.
My lord,
We
only
read all the files
just 2, my lord.
like students to appear in the exam every day till 12 o'clock. Sometimes it goes up to 1. And you think, that's why I said, come to the point. If we allow a hearing unnecessary arguments, only 2 cases will be taken up in a day. I don't know what about other case, other court.
My lord, with
And
apology.
then you make a complaint that we have not been heard. We hear the necessary. We will hear what is necessary. We'll not hear unnecessary, what is not necessary. I have indicated you, I have heard you now. What more I have to hear?
My lord, I will reply all.
So at the base, you may challenge this, the decision of the committee or the respondent authority, where you have been held to be ineligible. Because you doesn't have the degree, or the degree which you have obtained, it doesn't false. I mean, it
Not
cannot be
equivalent.
considered to be eligibility. I mean, a qualification as per the some rules
not
and the
equi-
regulation.
It's not equivalent.
No, not considered. You have to challenge that.
My lord, what happened, my lord, that.
If you want to withdraw the writ petition and will permit you to challenge the decision, then it's up to you.
That will be, because actually.
That
what-
would be better.
Yes, my lord.
By filing the reply, things will not change. Because wrongly or rightly, authorities has decided, I mean, come to the conclusion, findings that your degree which you have obtained is not equivalent as per the requirement of that group.
Yes, sir.
What do we call it?
Mechanical engineering, my lord. He has obtained his undergraduate in.
No adjournment. Sorry.
Undergraduate in
We cannot
instrumental.
adjourn it.
Instrumental.
Maybe it's a
engineering.
little harsh. It sounds harsh, but skill electric engineering as per government notification so and so 2024. There's a eligibility criteria must be provided in this notification. 7th October 2024.
The next week.
So your case has been removed from the foundation. Then once foundation is removed, superstructure falls automatically.
This is true, my lord. Actually, what happened, my lord? Rightly or wrongly, my lord, till the date of the cabinet decision, I was.
See, this appointment is for 4 months or until regular appointment. You go for a regular appointment because this will create a hurdles. The authority has decided you don't have the qualification, eligibility for assistant professor or lecturer. So don't go for this small thing. Aim for a higher, better, and bigger.
It's true, my lord, because after 2 months, my lord, the tenure
They are
of the
retiring.
CA will be.
They are retiring.
No, after 2 months, the tenure of
What
the
is
CA
your
will be
age?
over.
What is the age? What is
My
your
age
age?
is 27, my age,
Long way to go.
wrong way to go, yes.
You have ample opportunity. You will get ample opportunity in life.
43. No, but actually, what happened, my.
Aim for higher,
No, actually, my.
bigger.
My contention is that, my lord.
Heard, mister.
Deep.
What do you want? You want to withdraw or you want to withdraw and challenge the decision? Or will pass on merit? I'm dismissing the writ petition.
Then a liberty may be given, my lord.
No, I'm not forcing you. I have heard you, therefore I'll dismiss. I don't find any merit. I'm dismissing the writ on merit. If you want to withdraw and file, press whatever, that can be. We
That
cannot
observation.
stop you.
All right.
If it is not on the same cause of action.
Yes, madam.
What do you? It's up to you.
We do.
Withdraw.
Not place, madam.
Heard, Mr. D. Borwa,
Yes.
learned counsel for the petitioners. petitioner,
Petitioners.
two petitioners. Item 21,
Yes, ma'am.
here. The petitioners, and also heard Mr.
As does, my lord.
Is this learning the state council, learning standing council,
Higher education.
higher education, department, government of Assam, for all the respondents. Next para. Mr. D. Barwa, learned council, after arguing the matter at some length, having realized that the authorities, the respective authorities have considered their applications for appointment, for engagement, re-engagement as a assistant professor in view of the, in terms of the cabinet decision has returned with the findings that the the BTech degrees, the BTech in instrumental engineering of the petitioners. Both of you are
Yes, yes, ma'am.
same degree.
Same.
Is not relevant or equivalent subject to the electrical engineering as per government notification dated 07/10/2024. Press for withdrawal of the writ petition with a liberty to file a fresh. Mr. Next para. The prayer is allowed. The prayer of the learned council will be allowed. Mr. Accordingly, writ petition stands closed as withdrawn with a liberty as prayed for.
Oblige, your lord.
Lordship, matter has been wrongly listed before this court today. It's a bench for matter, Lordship.
Why this is wrongly listed?
It's a bench for matter, Lordship. You may be registered with mistake. Registered done by mistake, Lordship. Bench for matter, Lordship.
What is the matter?
A matter is compensation. Yes, compensation for language.
You prayed this morning.
Yes.
You did not say this morning.
Lordship, I did not notice at that time, Lordship.
Is there any bar? Is there any bar under the law?
Lordship is taking bench 2 and
It's a
3.
convenient of the court only. Anyway. But be honest. Don't change your stand. Now and then. You stick your prayer, the grounds of prayer. Just don't try to take advantage. There's no law. I can take it up. All right.
Yes. Lordship, and also we'll file rejoinder affidavit also in this case.
It's 2012 matter, the same thing. Anyway. On the prayer of Mr.
MJ Gogoi.
That is consent for the petitioner.
Yes.
Is this matter after 3 weeks as a last chance? After 3 weeks, please stop. As a last, no. After 3 weeks, so as to enable him to file affidavit in reply.
No, rejoinder affidavit.
Why, I call it the affidavit in reply. Is it a different thing?
No.
Is there any difference between rejoinder and affidavit in reply?
Reply.
Huh? Considering that the matter is pending since 2012. The matter is adjourned as a last chance. No, I adjourned for the last chance. Huh? Adjourned for last chance. What chance you say? Jump for the last.
Yeah, please, Your Lordship. This matter is relating to the appointment of assistant professor. We have challenged an advertisement.
Yes.
But BTC council will require in this case, but it is not available. BTC council.
Your challenge is what?
Well, not advertisement.
Why?
Okay, page 19. They have earmarked the post for reservation option.
What is
It
there
could-
is? You are saying that this cannot be reserved.
Yes,
It's not a reserve post.
this should not be reserved. It should be open.
Why?
Page 19.
By following the
Yeah,
roster
roster
point.
point. Yes, Lordship. Already, Lordship, out of 15 posts,
Yes. Nobody's there.
nobody is there.
What is their stand? What is their this stand?
My lord.
Have they filed the affidavit?
Yes, they have filed it.
What they are saying?
My lord, they are saying that this vacancy were at serial number 15. So it will fall under the category of reservation. But already 3 posts has already been reserved, occupied by the ST. That is, Your Lordship will find in their affidavit itself, filed on 3/12/2024.
Not Mr. M. Council for the non-APS for the BTC.
Well,
Respondents. BTC, respondents BTC. List the matter after 4 weeks. There is a stay.
yes, it's still there.
In that case, 2 weeks.
We are appearing for respondent number 5.
Who is respondent number 5?
My lord, principal of the college.
Huh?
Principal of the college.
Are you not serious?
Yes, sir. My lord, we are relying the my lord affidavit filed by the my lord,
What they are saying?
My lord.
What is their stand?
My lord, their stand is clear, my lord. This post is my lord,
Reserve for
reserved post.
STAP,
Yes,
STP.
yes.
Okay.
It has earlier also reserved.
Your BTC is not there.
BTC, my friend, is not available. Anyway,
After 3 weeks.
my lord.
Interim,
Interim order is vacated. Let them fill up. Let it be
BTC.
subject to the outcome.
BTC. Yeah. My friend is coming.
My lord, Mr. Beach already sending us a BTC appears for this matter, my lord. He is arguing a matter in code number 17, my lord. This will take some time, my lord.
After 3 weeks. If you are not interested.
No, my
you
lord,
fill up.
we are interested, but he's on right now. He's on legs, my lord.
Okay.
After
3 weeks.
1 week, my lord.
Can it be my lord, after a week, my lord?
2 weeks, 2 weeks. Make it 2 weeks.
Oblige, sir.
Obvious, my lord.
Interim order.
May I please, Your Lordship. May I please, Your Lordship. Lordship, in regard to this matter, my lord, here, my lord, we are in the process of adoption of notification issued by the finance department, my lord, regarding the minimum wage pay of the casual employers, my lord. So may I place before Your Lordship notification?
Madam, what is your prayer?
Lordship, my prayer is to regularize my service, Lordship, as a casual employee, Lordship. They are appointed in the year 1993, 94, 99, and 2001, Lordship.
On what basis? It's 2019 notification.
Yes, madam. My lord, we are in the process of adopting the notification, my lord.
So,
I'm praying for some time, my lord. My lord, similar repetition is also pending, my lord. Repetition number 8443/2022. My lord. Similar repetition is also pending, my lord. Repetition number 8443/2022. My lord.
22.
My lord, both the matter may be taken up, my lord. If my lord
Similar.
may allow. Yes.
It's that both the matter come up.
So after the open dust case,
Yes, lordship.
there is no automatic regular. It cannot be regular.
In fact,
The
lordship,
service cannot be regular.
in fact, lordship, on one occasion, lordship, on 13/2/2020, lordship, the council for the respondent number 3 and 4 submitted before this honorable court that they are under the process of regulation, lordship, and matter, and the proposal was sent to the handloom and textile department. So this honorable court asked the council for the handloom and textile department to take instruction regarding that proposal also, lordship.
That proposal, my lord, we have rejected long back.
Wrong way.
Because, my lord, there is no scope of regularization. After Upendas and my lord's judgment sitting in division bench, Ujala Najare. My lord, there is no scope of regularization, only minimum pay scale, my lord.
You were appointed since
1993, lordship.
still working.
Yes, some of them are working, lordship, 93, 94, 99, and 2001, lordship.
Okay, so we'll take it up along with that.
Yes, lordship. Yes.
You filed have you filed the affidavit?
Yes, ma'am.
My lord, I haven't filed, but I have a written instruction, my lord.
You filed it?
Let him file
You
affidavit.
also filed it.
I will file.
Yes.
Because they are seeking regulation. If it's not possible,
Yes.
what could be the way out?
In fact, after Uma Devi, they have regularized, lordship, 11% below us, lordship. That was also my case, lordship.
You have pleaded. It's your pleaded case.
Yes, yes, lordship.
You filed an affidavit.
Professional appointment.
My lord,
In the
It's
election
your
2012,
your
lordship.
department.
no, no.
After
I am not responsible for
Yeah,
their
working-
regularization. I am the government, my lord.
Ah,
My lord, we said that there is no scope of regularization after Upendas. There is a finance OM and
you are for finance,
no, my lord, I am for the
And-
handloom and textile, my lord, the department.
who is working under
Yes.
under the.
No, my lord, they are working under Khadi. We give them grant in aid.
Acha.
We just give them a grant in aid to maintain. But it is their lookout, they have their own board. It's an independent autonomous organization. They have to, my lord, feed their own employees. We just provide a grant in aid yearly.
let him file one affidavit, lordship.
You filed an affidavit.
I can file, my lord.
Her MS,
P. Bhattacharya.
but it's a non-council application. And so.
A. Gayan on behalf of PK Muni for the respondent number 3 and 4.
Mr. Ardhar,
Hello.
learned counsel for the
Handloom
the standing council, handloom and
textile.
textile is granted for the 2 weeks time to file affidavit. List this matter along with WPC
WPC number 8443/2022.
844 3
2022.
24
22.
22.
Much obliged.
Obliged.
Not a very short point involved. The point is whether a substantive employee,
Can we?
it should not take more than 15 minutes from my side.
Mr. K. Gogoi is coming.
Huh?
Mr. K. Gogoi is coming, my lord. He'll argue.
Okay, all right. Let's see next week.
Or in that case, my lord,
It is 3:30 already.
in that case, my lord, can it be on 3rd? Till 2nd, I'm traveling in Arunachal. 3rd.
Okay. Are you agreeable?
Yes, yes.
Hard Mr. I told it, one senior counsel assistant.
T. Das.
And Mr.
Yes, that's my lord.
Elvis. Correspondence.
Yes, my lord.
These are
Narrative is-
2017 17 matter.
One is 17, one is 22.
22.
There are
One
two.
is what? First one is,
My lord, the issue is like this, brother. I was appointed originally appointed in Jorhat Engineering College. Substantive appointment is there. So there was an advertisement by Guwahati University for a particular post. I applied. That appointment was for 5 years. They said initially for 5 years.
okay, lien and all. those
Lien.
things. Okay, we'll try. We'll see
Well,
on 20.
Otherwise, facts are slightly long, but point is very short. And it is squarely covered.
Nowadays will not go to the facts that long.
Obliged.
Lordship, this matter pertains to grant of financial assistance. Pertains to grant of financial assistance to the venture education institution in the state of Assam. And accordingly, the petitioners schools were eligible to receive the same. When they were deprived, they approached the Honorable High Court. Lordship may kindly see the judgment passed by the Honorable High Court, order passed that case, Your Lordship. May I take your Lordship to page number 59. Page number 59, Your Lordship. Starts from 16. Heard Mr. P. Sharma, learned counsel for the petitioner, as well as Mr. P. N. Goswami, learned standing counsel education. According to the petitioner, numbering 13, which are ventures high schools, they are entitled to get financial assistance as per the scheme formulated by the state government, the education department. It is their plea that their names were included in the list of 42 schools, but in view of the ensuing election, the financial assistance could not be disbursed. In the counter affidavit filed by the respondents, it has been stated that a proposal was made to provide financial assistance to the petitioner schools was mooted, but the finance declined to accept the same in view of the ensuing election. It has further been stated that after the election was over, the state government took a decision to discontinue the scheme. Mr. P. Sharma, learned counsel for the petitioner, submits that the decision to discontinue the scheme cannot be operated retrospectively. He submits that since the proposal was mooted prior to the model code of conduct came into operation, the said proposal is required to be approved by the finance department. Considering the grievances raised and as agreed by the council for the parties, this petition is disposed of, directing the respondents to look into the grievance of the petitioner.
Where's the secretary? Decision of the secretary? Order 08012/2014. This is the basis of your claim.
Your Lordship.
8 December 2014 order is where? Where is that order?
8 December. 8 December.
Page 86.
Yes. 8 December, yes. 86. Page number 86. This is in view of the second round of litigations, when my matter was not considered even after the first litigation. Yes, this is the main order, Your Lordship.
The 13 schools mentioned in WPC are entered to receive financial assistance for period of 2000. And necessarily, what do you mean by that? Is they received before using 21? This is based on the last order of this court.
Yes.
Right.
Yes. Second round of
litigation. So what happened thereafter?
Thereafter, Your Lordship.
No action.
Yes.
Yes.
Thereafter, they have issued certain letter, Your Lordship may.
Saying rejecting your claim.
Yes, Your Lordship.
Rejecting your claim.
Not exactly rejected. They stopped thereafter.
So you want that as per this order, you should be provided with financial assistance.
Yes. Your Lordship may kindly see
Yes.
page. Yes.
That's all. Anything else?
Yes. Your
That's
Lordship.
all. You want financial.
Now, thereafter, Your Lordship, they.
Financial assistance.
Yes.
As per the order, this order.
Yes, yes.
That's all.
That's all.
Anything you want more?
Thereafter, certain letters were even issued.
Issued to what? For?
In connection with this order, Your Lordship.
No, for what?
For the taking action to follow up this order, Your Lordship.
It's okay. But then nothing had happened.
Nothing.
Yeah.
My lord, financial assistance, that scheme was introduced earlier, my lord. subsequently, my lord, Assam Venture Education Act, Provincialization Act 2011, my lord. There is a provision under section 3, subsection 6, my lord. Then that act has, but there is no any financial, my lord, assistance to the school, my lord. And subsequently, this 2011 Act also, my lord, this is also set aside by the Honorable Court, and 2017 Act has been, my lord, introduced, my lord. And if, my lord, we come to the 2011 Act, my lord, that is very much clear, my lord.
No, it's okay. This court has directed to consider their case for financial assistance by order dated 10/4/2014.
My lord.
When the act was in force, right?
My lord.
2011. Now, by this 18 December order, you have said Secretary to Government Assam Secondary Education, there's 13 schools.
My lord.
You are 13 schools,
Yes,
same 13 schools.
Not now 13, that 3 remaining they left out, your lordship, because they are financially not.
So how many?
Now, your lordship,
10
altogether,
schools.
altogether 10 schools.
10 schools are entitled for financial assistance for the period 2011-2013 and necessary 13 for them up to 2015. It's your decision only.
My lord.
So,
Even, my lord, that order has passed, my lord, but there's the scheme,
and
my lord, does not.
they filed a writ petition.
My lord.
When? Before the enactment is to come into force. The new enactment.
2017, my lord.
Yes.
This is 2017 only.
So,
This is a 14 order.
what sort of financial assistance? How much you will get?
Your lordship, amount is not exactly, your lordship, they have,
No, according to roughly, approximately.
excellent, your lordship. One crore 92 lakhs 12,864. That is as per page 91, annexure Q. The bottom portion. Annexure Q, page 91. Government is therefore requested kindly to accord necessary sanction of rupees 1 crore 92 lakhs 12,864.
What about this writ petition 575 of 2050?
Yes, your lordship. Yes.
Seven 575. Ayodhya Rai Memorial High School,
If that petition has been dismissed due to non-appearance of the petition.
non-prosecution. Problem is You have decided yourself. Now you cannot say that it is barred by the law now.
No, my lord, that.
You could have
that-
taken
that
a
is the-
call.
My lord, that
You
will be-
could have filed a review. You could have taken revisit your decision. It is by the secretary,
my lord,
not a clerk.
even my lord,
It's
we
not
are.
a decision of the clerk.
Your lordship, may
If a
kindly-
decision is taken by your, by government, it can be always revisit.
My lord, even my lord,
No,
otherwise
no,
also, my
you
lord.
cannot take a stand by saying it is by law issued. And that too, the consideration is in terms of this court. What is this last order? 110 for 2024.
My lord.
Order of the court.
Page number 74, my lord.
74.
Starting for 68, my lord, 11%, 74.
In view of the above discussion, response are directed to provide financial assistance in schools in person for the year to must reach the prison within an outer limit of 1 month. This is a clear direction.
My lord.
It's
My
not
lord,
a decision.
Therefore, my lord, I am submitting, my lord, because there is already a direction of the writ petition is there, my lord. And claim may be petitioner proper, but that this way, my lord, again, my lord, second writ petition is not mandatable, my lord. Same direction, court already direction is there, my lord. Court has given a certain direction, that is the mandamus is there, my lord.
It's
Again, my
okay.
lord, same direction, my lord, same issue, my lord, he cannot come with another writ petition, my lord.
No, you cannot take advantage.
Even a lordship may kindly see page number 93.
It's not only for consider, directed to provide
The
financial.
mandamus is there, my lord. Even there is a chance to file the contempt petition, my lord, against that man on that point of time, because 2017 he filed, my lord, and 2017 11 act has stuck down, my lord. And it will not depend on the now administrative department, in a question of the financial and judicial department, he also, my lord.
Yes, he has also, he has also point.
Which one, your lordship? The second repetition
In
is
2014, you have been directed to provide a financial assistance by the court.
yes.
You have slept over the matter. You have filed a writ petition in 2017.
Yes. They didn't deny your lordship. They didn't deny. Even your lordship may kindly see page 93. Page 93, your lordship, annexure S. This was issued from the director to the secretary to the government of Assam under the subject regarding proposal for
70, page
93.
93,
93.
90.
93.
Yes.
Yes.
Secretary to the.
From director to the secretary regarding proposal for sanction of FA as per Honorable High Court's order dated 10/4/14 passed in WPC number 5386/13 filed by the Johannesburg High School and others versus State of Assam and others. Reference to this government letter, with reference to the subject cited above, I have the honor to state that white order dated so and so passed in WPC number so and so filed by the Johannesburg High School and 12 others. The Honorable High Court directed to pay FA to the schools in question 13 in number for the year 2010-11 as well as also for the year 12-13. Such benefits must reach the petitioners within outer limit of 4 months. Senior standing counsel advised to file appeal, but White his letter dated so and so, he opined that appeal oblique review will not lie. Against the order passed in the second repetition, that against that order, no appeal or review lie.
My lord, when we are going to the order of the his pair, my lord, his pair, my lord, he is claiming the execution of 10/4/2024 order. Apart from there, my lord, no is a pair also there. The 10/4/2014, my lord, that execution can be only contempt petition. My lord. If you go to the page number 14, the pair of the repetition.
They have approached you again and again. You have not denied, you have not
That-
filed appeal.
That's my lord.
You have
I have
decided
my lord.
there's
That's
no
regards. My
ground
lord,
for appeal or review.
my lord.
They didn't deny, they didn't deny.
No, no, I am not denying. I am saying that I am raising the question of the maintainability of petition on the basis of this pair, my lord. Because my lord, direction is already there that in mandamus he can file the contempt petition.
Why don't you act?
No, my lord, because my lord, that is his hands of circumstance. Even 2011 also, my lord, no given the right to the petitioner for
At
financial
that
assistance.
time, you have not pointed out that.
My lord.
Even that was not pointed out.
2011 Act, my lord, when he is claiming that there is a no entitlement under 2011 also. My lord. That three subsection 6 is clear, my lord.
That was not,
Subsequent to that, my lord, that 11 Act also stuck down, my lord, 2017. And 17 also no provision for the financial assistance. My lord.
so while your second round of litigation was under process, they didn't raise this question regarding the bar. And so far, your lordship, the 2011 Act is concerned, that has been declared unconstitutional.
Heard Mr. So-and-so, learned consecutive position. And also heard so-and-so, and both of them.
Sorry.
Please, sir.
Leave this matter on 4th 04/04/2020 for further consideration. Think over it.
My lord.
I'm not agreeable to your, I'm not persuaded. Maintainability. Is a direction. I am conscious that
My lord, can it be after Bihu
there
vacation?
cannot be order over and again.
My lord, can it be after Bihu vacation, my lord?
Why?
No, let it be on 4, your lordship. Let it be.
Then after we vacation, we consider. I'll make it part hard.
Okay. My lord.
Okay, okay.
After we.
Part hard,
Made
part
in
hard.
that case. After 4 weeks.
Let it remain as a part of your lordship and any record.
Think about it.
My lord.
There's nothing much to be deliberate.
My lord. My son.
May I please, your lordship?
Yes.
Lordship, may we please-
Lord, we will be
Lordship,
filing,
please to peruse the last order. Please open the report.
Lord, we will be filing affidavit, my lord. Affidavit is ready, actually. I could not serve it today, my lord. I'll give her a copy, my lord.
What is the matter?
My lord, the matter before your lordship, the petitioner before your lordship, she was, as per advertisement and selection. After interview, she was appointed to a non-sanctioned post in the year on 25/8/2004. My lord, from 2005/8/2004, she has all her qualifications and she has been continuing in the non-sanctioned post. Initially as 2000 as honorary 2000 and now she is getting 4000 monthly, my lord. And my lord, during the pendency, my lord, government notifications have come up. I have also annexed those government notifications. My lord may be pleased to peruse firstly one notification at Annexa 10, page 31, where my lord, the government has called for the principle that all those who are working in a non-sanctioned post appointed prior to 12/10/2004, their names may be submitted. In between, petitioner's name was submitted 2-3 times, my lord. And again in 2014, those notification again came and petitioner's name was submitted. In between, during the pendency of the name of the petitioner, while was forwarded as per the direction of the government by the principal of the college has issued an advertisement to fill up the said post. And this honorable court, my lord, in the interim has stated advertisement, my lord. And the matter is pending with regard to the affidavit of the department.
Okay, if there is stay, we'll give them a
My lord,
last
yes,
chance.
my lord, my lord.
I'll be
my-
filing, my lord,
my
affidavit.
lord,
Last chance.
my lord,
Yes, I'll be filing today or tomorrow, my lord. It's ready.
my lord, can it be
But
next week?
MS one contact for the petitioner.
My lord,
Mr. Yes,
Yes, yes.
learned standing council,
Higher education department.
higher education. Praise for a week's time to file the affidavit. Praise the Lord. The list the matter after 2 weeks.
my lord,
In the meantime, the No, it is made clear that the learned disturbing council is granted this opportunity for filing affidavit as a last opportunity.
My lord, can I get a date, my lord? My lord, there is urgency on my part.
What urgency?
My lord, I have also annexed before your lordship one
You are
affidavit.
working.
Yes, no, my
Are
lord,
you
the
still-
issue is that.
Are you
they are
still
res-
working?
Yes, my lord, respondent number 3, the principal has not come before.
Agency should be them.
No, my
Fill
lord,
up the post.
I have filed an affidavit to this honorable court. Respondent number 3, after receiving dusty, has also not appeared and he's threatening to oust me from service, my lord.
Huh?
Here, yes, my lord, I have brought on record and I am a widow with 10 years old.
Don't pretend.
My lord, I have submitted.
not- We'll
not
take
make
it
that.
It was
seriously.
not against the respondent, but my lord, it did.
You appraise the principal. Through your good office. Appraise. He's the principal.
No,
No,
he's also from.
principal is not
Actually,
appearing.
he was looking after the matter.
You send a message across. You, by using your good office. We will take it very seriously.
Yes, sir. Absolutely.
Since she has brought on record the
Yes,
allegation.
sir. Will inform my lord.
Because can it be 22nd? Obliged, my lord.
May I please? In this case, the petitioner is a jail warder, my lord. My lord, he was
There,
jail warder.
there was that.
Yes, my lord. Lord, while he was in service in Guwahati jail, my lord, one detained was escaped. On that particular day, at least 5 persons were there.
Pleadings are complete.
Lordship, record is not received, Lordship. Record not received.
This is against the dismissal, removal from service.
Punishment
Of what?
withholding of one increment.
We'll see the records. We'll see. What do you want to say?
This is a list of decimal, we have submit this list.
List of, no, not today. We'll,
That may be fixed, my lord.
not Mr. So and so learned counsel for the petitioner. List on the prayer of Mr. J.K. Goswami, learning senior, additional senior government advocate. List this matter after
Behave vacation.
3 weeks.
Lords.
To show is to enable him to produce the reports. List after 2 weeks.
Well, specific date may be given, my lord.
It's very difficult to give a specific.
Well, other it is also difficult to bring the case.
After 3 weeks, Puja.
Behave.
In this case, actually, I was directed to produce the original record of this disciplinary proceeding, my lord. Actually, I have received not the full entire record, my lord, actually. And part of the record I have received, my lord. And let it start, my lord, the next week, in the next day, I will produce the record also, my lord.
Let us not, otherwise also we have not enough time.
Not enough time, that is true,
So we'll do it next day after puja. Because next 2 weeks, it's all full. Even if it listed also, same thing will happen. Unnecessary listing the method would be troubling you.
That is true.
After vacation, after the Bihu vacation.
Let it be on
Senior
Second,
learners,
Milan,
you enjoy the
22nd.
Bihu and then, yeah.
22nd.
Not
Yeah,
22nd,
22nd.
22nd is also full. After 23rd,
24th, my lord.
24th. Mr. Learned senior counsel, assisted by.
I'm right.
Till my lord, on the 20th, my lord,
And Mr.
24, my lord. Let it be on 29, my lord.
Learned senior counsel assisted by.
By
For respondent number, sir, you are for respondent number?
2, 3, and 4, my lord. All the respondents.
For respondents. Is agreed to when consulted when senior consultant.
29, no?
This matter. 29.
20, my lord.
29.
My lord. Bless you, Lord.
But after Bihu,
My lord.
is there any urgency? What is the matter?
No, my lord, I have been removed from service after disciplinary proceedings. And
When was the impugn order?
my lord, the impugn order has been passed on
10th July.
14th of July 2023.
You were working as
I was, my lord, working as an officer of the bank, my lord. State Bank Authority.
possible. You have the records.
No, my lord.
Records will be required also.
Records, my
After
lord, your
hearing, we'll
worship,
do it like.
I like to presume, but what I submit is that, my lord, let me start today, my lord, at least some portion I will get.
Not next.
I
In
submit,
fact,
my lord,
I don't want to inform, but I have some work also.
my lord.
And we have some administrative work also. It's about to fall. After Bihu.
My lord, my intention was that, my lord. If the matter is pardoned, my lord, it takes a precedence and it gets the matter.
What's the- what's
It
the-
did
how
not
next
reach
day?
for a long time, my lord.
Huh?
It was in the list for a long time, did not reach. That's why, my lord, if your lordship hears at least for some time.
Okay, we'll take note of it next step. On next step. Today is not possible. And Mr. M.K. Cholu, then is senior counsel. Assisted by Mr. B.K. Jain, then counsel for the petition. And also
Mr. A.K. Sahib.
A.K. Sahibal, then counsel for respondent number 126.
My lord.
Has agreed to, when, let us give a fixed date. It's a dismissal from service.
24th of April, my lord, if convenient.
24th. 24th is the hearing day.
Yes, my lord.
As agreed to by learned counsel for the party, list is matter on 24/04/2025. Mrs. You are for the bank,
My lord.
Sahib learned counsel to produce the records in the next. We'll hear you and we'll produce the records also.
So my only worry is, my lord, the item always gets, my lord, down in the list and doesn't reach.
No, it's very difficult, as you know.
That's why, my lord, I thought that I'll argue a little, my lord, and your lordship would
Sitting-
physically order
sitting-
so that on the next that your lordship can take
Sitting
it.
in principal seat, it's I'm just sharing as not complaining.
Complaint.
It appears to be little taking a toll to the health also, to the judges. Anyway.